Good morning. Oh, come on. Really? Good morning. All right.
Good morning.
All right. Good morning. On behalf of myself, Judge Servito and Judge Hood, welcome to the first day of our case call panel. I see some familiar faces in our courtroom today. And I want you to know that we do understand that these cases that we are hearing today are important to you. We have had the benefit of your excellent briefing as well as the work of our research division and our chambers. I can assure you that we are familiar with the relevant facts and the pertinent law, and we would ask you to focus on your salient points, keeping in mind our role as an error correcting court. Today, we are also hearing some matters that involve children and sexual assault victims. Because these proceedings are recorded, we would ask that you please substitute initials in lieu of using a minor or victim's full name in those cases. Also, Judge Servito may have to get up and move around due to a medical condition, but please be assured that she is engaged in this process. We have had already, prior to coming to court today, several discussions about the cases that we'll be hearing today. I hope no one's shocked by that. We are actually prepared. So with that, I'm going to call item number 17. We're taking this case out of order. It is docket number 359213, Legacy Custom Builders, Inc. versus Sally A. Norrogers. Could you come to a podium because we're also recording? If you could put your appearance on again, that would be wonderful.
Sure. For the appellant, Brian Hirschfuss, appearing on behalf of Legacy Custom Builders.
Okay. All right. You may proceed.
Thank you so much. With full recognition what the court has just given as its preamble in terms of having read the briefs and certainly being upped on the facts. This case doesn't have really a lot of facts. It's really is substantively, it's the law that's really at issue over here. My client does custom construction. The defendant, who is the appellee in this matter, didn't pay. They terminated the contract. And after that, my client recorded a claim of lien pursuant to statute. 3 attorneys later, nobody's notified my client what they allegedly did wrong, but what the...
Well, I mean, we have letters between the lawyers, right? There is some dispute as to who breached the contract first.
Well, no, my client says straight out, we terminated the agreement because they didn't pay, and we terminated the agreement because they wouldn't make decisions. So that nobody's taking any issue with. What they're doing is, and they've actually put this in writing, we're not required to give you that information until we go to arbitration. So what's the issue? Well, the issue is the defendant appellee went and paid all the subcontractors. So it's not an issue with work that was done. The only issue is she hasn't paid us. So again, we don't physically do the work. We retain subcontractors. They do the work, and thereafter they get paid. We record a lien. Now we're bumping up towards that 1-year period of time, and my client files we filed the lawsuit on behalf of my client. We do 2 things. One is based on the terminology in the written agreement. If there is a dispute, you take that to arbitration, which, by the way, is a defense. It can be waived. You don't have to go to arbitration. It can be waived. Okay. In this case, the first pleading coming from the defendant appellee is a motion for summary disposition. Our objection, of course, is a threefold. One is putting aside if there is an issue to be arbitrated. Let's just say the court said, look, I think that it's an issue, go to arbitration. We wouldn't be here today. The problem is what the court did was it dismissed the case in its entirety, and that includes the foreclosure proceeding, which the statute says you must file in that county and you must do it within 1 year or you lose your right to foreclose. A little disingenuous, but the position of the defendant appellee is, don't worry about it. You filed, that's good enough. Yeah, but there's no law that says that. The law says you must file your action. And one of the things that we did, especially on the motion for reconsideration, we said to the court, we're okay, we'll go to arbitration. but you at least stay the proceedings as it relates to our lien foreclosure, and now we're preserved.
Counsel, is there a reason why you didn't do that on the front end? Move for a stay pending arbitration kind of right after your client files the complaint?
Well, the short answer is yes. If we're going to have to litigate the lien claim, it certainly would make sense to do everything in one forum. They have a right to say, no, we don't want to litigate the underlying issue, if there is such an issue, but they have a right to say, we don't want to litigate it. We want to arbitrate it. Then I would have to dismiss. What they did was it was an all or nothing proposition. They don't want to just dismiss the claim. Let's litigate. You owe me money. No, I don't. They want to litigate the issue. They want dismissed. And the judge did it, was the lien claim foreclosure. Now we are totally out of the statute. We are well past the 1-year period of time. And by no means of not an important point. Here we are, since this all started, we still do not have, pursuant to that agreement, we don't have an arbitrator. The selection process happens with basically from the board. They make a selection of an arbitrator who's a builder. And I think, and Mr. Cohen can correct me, I think there have been 4 or 5 different arbitrators, and this has gone back well over a year.
Counsel, sorry, just to backtrack to make sure I didn't miss it. When you first filed the complaint, if you know that you're going to go to arbitration anyway, is there a reason why you didn't immediately file a motion to stay proceedings pending that arbitration?
Yes, one of our contentions are that we don't have to go to arbitration. So, I mean, we said that right up front. We don't have to, and that's what I said. Had the court said I disagree with you, we wouldn't be here. It's the lien portion that becomes the issue, because now I'm past my 1 year, and the statute is very clear. It's sub 118 that says it's in the county where that lien arises, where basically where the home is located. So that's, again, I don't want to minimize the fact that I don't think that there's an issue that has ever been disclosed that we should be arbitrating, but that's not by any means the strong issue before this court. What's the strong issue before this panel is that a judge left us hanging, and that's why my motion for reconsideration says, look, you want to just dismiss the underlying claim itself. Okay, the Ronish case tells you how to parcel both, put them together at the end, and there you're entitled to your attorney fees and costs, subject, of course, to the court's approval, but you're entitled to them, and then the court tells you how to put them all together. You get costs and attorney fees in the litigation, as well as the arbitration. You put them together, and that's what makes up your lien foreclosure, the dollar amount. We know that. So that's why I said to the court in my motion for reconsideration, forget that side, but at the minimum, just give me a stay of proceedings on the claim of lien, so I don't blow the statute and I follow the statute county-wise and time-wise, and then we'll proceed from there. And the court basically was a denial. You haven't addressed anything new or shown the court where there was any error. Some of substance, that's where it is. And I understand you've read the underlying law, where there are pages and pages of law that support it. The one thing I want to make abundantly clear, the appellee in this matter files a response brief, their brief on appeal, and they give a lot of law. I don't have an issue with their law. I have an issue with the application of that law. For example, one of the things they say is, well, the fact that you file, quite gratuitous, the fact that you filed, you're good enough, but there's no law that says that. And I suspect, although this is not the forum to wager bets, I suspect they would be the first people to say, you blew your year, you didn't file it, therefore you're not entitled to pursue the claim of lien and get your attorney fees and costs, foreclose on the home if you're not paid. And that's the underlying philosophy of this claim of lien of the statute. The builder gives improvements. He's entitled to be paid for it. And if he's not going to get paid, he has a way, he has a resource, the house, foreclosing on it, and then finding a form that he can foreclose on within, and then collect the money. We have that. The problem is I was foreclosed to that. And I suspect if I turned around, if we had arbitrated this case and I had gotten an award in this case, I would probably be standing in front of the circuit court saying, well, now I'm filing again. And somebody would say, but the court didn't dismiss your case without prejudice. The court dismissed your case with prejudice, which means I've just blown my claim of lien, which I did file according to statute. So again, I don't want to minimize the underlying claim, I think they have an obligation to tell me what the issue is. Tell me I did a bad foundation. Tell me they did, by the way. Tell me, we put a bad roof on, whatever they want to make up. Now I have an issue. And I've attached correspondence from the appellee's counsel, which is abundantly clear. No, when we're in arbitration, we'll give it to you. What am I filing for then? And that's why my position is I'm entitled to go to the circuit court without stopping first and going to arbitrate a claim, because I don't have a claim to arbitrate under my written agreement. It's written broad and general enough that I don't have an obligation. Again, if the circuit court, if this panel disagrees with me, that's okay. The real core issue is my claim of lien, and to preserve that claim of lien so I don't get held. As I say, here I am trying to arbitrate the case, no fault of Mr. Cohen's office, no fault of my office. And now we just got, I think it was on Sunday, we just got notice from the head of the president of the association saying he's frustrated, I'll just do it. Well, that may be a problem since all of us have talked to him in an effort to get arbitrators, and I'm not sure that's a smart idea, but that's where we're in this case. And it's no fault of anybody's. Unfortunately, that's life, that happened. But my main concern, of course, is the preservation of the lien. Having said that, and I'd like to reserve just a few moments, for rebuttal. I do want to say this also. I'm not one in the ordinary course of business that takes a court rule and wants to twist it and say, look, I'm entitled, under that court rule. But when the motion for summary disposition was filed, there was no contact made. And today we're in the electronic stage, so we don't get precipice anymore. I wouldn't know what it says or what it doesn't say. But we raised that issue to the court, and I think we've put it in the brief. It's mandated, the sanctions. You don't call the other attorney. It's not Mr. Cohen's office. But the point is, when it was done, and I called that other attorney after it was done, and again, from my perspective, at least I made an effort to talk to him. It wasn't my obligation, but at least I tried that. And it fell on deaf ears. But that's the whole reason you're supposed to make contact, so that you actually can have a dialogue. You can actually talk about it. That never happened. It was just filing of the pleadings. Court then hears it, and this court heard it pretty quickly. I mean, there was no oral argument. I mean, it did it on the briefs, and then we're done. And I think that if the court rule is there, and it's there for a reason, it must be upheld. And we addressed that in the motion for reconsideration too. And the court didn't seem overly impressed with that. And again, just out of hand, dismissed that. But the core of this case is preservation of that lien. We did it right. And I think we need a court to be able to say, even if you have to arbitrate, when you file that case and you ask for your lien foreclosure, then the circuit court should stay it, because now you've complied with the statute. Stay that proceeding or let it go on. I mean, if there's some other thing to do, I can't imagine what there would be doing if you're going to be arbitrating the underlying cause. It should just sit there. Somebody has to tell that to the circuit court, because what they're saying is, nope, go arbitrate it. And that's not what the statute requires. Thank you so much. Unless you have questions, as I say, I'd like my rebuttal. Thank you.
Thank you. You have adequate time for rebuttal.
May it please the court, my name is Stephen Cohen, and I appear on behalf of the appellee. Your honors, first, I'd like to thank the court for its consideration, both to brother counsel and myself, for moving the hearing to today. We very much appreciate that.
We're sorry that it was even scheduled on that day. Believe me.
Somebody scheduled the school count day for the same day tomorrow also, Judge.
I heard. It's terrible. It really is.
These things happen, but pursuant to the comments of Judge Hood, I'd like to address the answer to your question, which was avoided. If you look at the complaint, which is in the appendix, Mr. Hirschfuss never asked for arbitration at all. All of his counts go to breach of contract, promissory estoppel, quantum merit, and the lien foreclosure. He never asked for it. If you look at, and also, Judge Letica, your comments are correct. At pages 64 and 65 of appellant's appendix, you'll find a letter from Richard Hoffman, who is a friend of my client's, asking, outlining what some of the problems were. So everybody knew what the problems were. And if you look at the contract provided that Mr. Hirschfuss's client gets 17% over costs. All right, so what's cost? Contract is in the media as well, before you, identifies how to figure out costs. So if you're going to have to pay 17% over costs and you're not sure that the costs are accurate, you ask for the bills. That's the basis of why Rising Etherington wrote their letter and subsequent. Now I have to explain, I came in after Mr. Gadd because Mr. Gadd got called to trial. He filed the motion that's before the court. And I want to address just briefly the last point, which is the issue of did he call? And I want to indicate the following. Legacy walks off this job and the contract says at paragraph 15, the determination of a contract says that they may terminate. The purchaser didn't need to list breaches once Legacy terminated. Look at page 28 of the median. It's the letter of January 26, 2021. The contract says she has to pay 17%. And at paragraph 3A, it talks about how you document that. My letter of July 28. Now I talked to Mr. Hirschfuss because first of all, I know him. Second of all, why not? And I had a conversation and I identified in my letter of July 28, which appears in the appendix at pages 69 and 70, what I understood our agreement was. And all I asked him for, and I said, I'm going to agree to a stay to solve any of your problems. And give me 3 weeks and I will give you a bill of particulars. 21 days. Even if I were, even if the court hated me, they'd give me 14 days. So I figured 21 days. He doesn't accept that. What he does is he writes back the next day, actually that night at 1:31 in the morning, which is at page 122 of your media. And he writes back, your attached letter is in errors to several points. He then ends it by saying, give me the letter and address alleged issues, and I will then stay the litigation and file for the arbitration, which you can file too, which is basically telling me to go pound salt. I am not the one who filed, Mr. Gadd filed the original motion. But at that point, there were letters, and it's replete through the record, that he was told, we're going through with this. We're not going to go to arbitration. So when he had to file his first responsive pleading, which under the court rule 2116 requires him to raise the issue of jurisdiction for arbitration. The concept of him having to call and seek concurrence for something he's already gotten a letter saying, I'm not going to do, with a complaint that specifically doesn't identify the arbitration clause, is putting form over substance. It's a nullity. You're not required to take an action that is an impossibility. So with respect to Mr. Gadd, who is the subject of the sanctions request on his behalf, and I haven't asked him for permission to address that, but it makes no sense, and the court made the right ruling. Now let's get back to the important circumstances of this case. You're right, Judge Hood. He should have and could have asked the court to stay the matter. He could have done 100 different things. He could have accepted my offer to stay the matter. But let's ask what the practical effect is on your court. And I think the three of you know that Mr. Hirschfuss's client drafted the contract, not my client. They're the ones who asked for the arbitration. Had the arbitration clause not been there, they wouldn't have had any problems. But they chose that. And by filing in court, what Mr. Hirschfuss's client did was put my client at terror. Not only does she have the obligation perhaps to go to arbitration, but she has to hire a lawyer for a circuit court action, which she didn't bargain for. She bargained for an arbitration where she splits the cost. He chose his remedy, and now he doesn't like his remedy because perhaps when they drafted the contract, and I don't know that Mr. Hirschfuss did, I doubt it. It's probably a form contract that many builders use. Contracts offer Mr. Justice Internet, which boggles my mind. But that having been said, they chose to have this clause and she abided by it. If they hadn't messed around with the process, they should have and could have been able to complete the arbitration, notwithstanding anything, within a year. They also filed the claim of lien and then filed their action to foreclose the lien. They didn't wait 90 days after the last date. They canceled the contract in January. They filed a lien in February. They could have waited up to 90 days to extend the period to try and resolve, which they didn't do.
But isn't that 90 days? That's the end of the line.
Sure. But like any law office, you diary things. So maybe you file it at 60 to buy yourself the extra 30 if you're really trying to resolve, if you're really worried about a foreclosure action. Now, what's the practical effect of arbitration? If we've learned anything from Ronish and the other cases that have been cited, Ronish says that once the arbitrator comes back and says that you're liable, the court can and will impose, the arbitrator can impose statutory attorney fees under the act. That's what it says. So what if he had blown the year? And what if I'm wrong? And what if my successor, if I don't make it through this process? Based on my age, there's some question about that. But let's say at the end, he gets a judgment against my client, which I think is highly unlikely. But let's assume. He then goes to court and asks to enforce the arbitration award in a judgment. The court, the circuit court then has the right and has the authority to foreclose judicially the same lien that he's concerned that he's not going to get in a year. There is a distinction without a difference. He's got Ronish that says he's going to be able to get attorney fees if the arbitrator agrees with him. He's got all the rights he ever had. But the key is, and I think Judge Hood, you honed in on it, all he had to do was ask the court for a declaratory judgment, not that he was right and we were wrong, but say, listen, I want to preserve my rights to a lien. Let me go to arbitration. I don't recall in 45 years, the last time I've heard a circuit court judge say, no, I want an extra case on my docket. I don't want you to go to arbitration. Just doesn't happen in the world.
Just to be clear, so am I correct in understanding that the common practice then would have been for him to file the complaint seeking to foreclose the construction lien and either contemporaneously or shortly thereafter file a motion to stay proceedings pending arbitration?
It's not the common practice.
Okay.
Because it's not common to have an arbitration clause and the lien in the same contract, in my experience. That having been said, he could have done that. Once the motion got filed, he could have agreed, which I thought we had an agreement that we would enter into a stay. He eschewed that and then brought upon himself the problem he's now facing. But it's not a problem because the practical application is he has his remedy. Now, the court dismissing it with prejudice was requested and was reasonable on the basis of the contract. Also, don't forget, Mr. Hirschfuss talked about Ronish and everything else below. Judge Matthews knew about that, and she knew what the practical application was. So I'm assuming she dismissed it with prejudice, not to destroy his lien rights, but because the law was there and it should go to arbitration, and his lien rights would be preserved anyhow. The issue of whether or not he told the statute. Now, if he had written a letter, I mean, I could think of 100 different things he could have done. He could have written a letter to my client and said, listen, I want to toll the statute. Do I have your agreement? Didn't do that. When her first lawyer, who was a friend of hers, entered to represent her, could have told that to that gentleman. Didn't do that. Instead, in the rather bellicose nature of the communications back and forth and the accusations of Mr. Cohen's the third attorney in, well, Your Honors, that doesn't make a darn bit of difference. The fact that Ms. Rogers has had to lower herself to hire me as opposed to the other two is perhaps my good luck and her bad luck. That having been said, all of these things, the motion for summary disposition was filed on June 29, 2021. Before I entered the case, Legacy wrote the contract and it filed its lien notice. Now, all the time from June 29 until the time the court rules on the motion for summary disposition, nothing's happened. Nothing's happened. And one of the things that Mr. Hirschfuss mentioned that there have been 4 or 5, no, there was an arbitrator picked, a man named Don Pratt. Mr. Pratt disqualified himself. He claimed he had a conflict of interest. After Mr. Pratt, there was another gentleman who was appointed, but his builder's license had lapsed. And the requirement of the contract says you have to have an active builder's license. So it would have taken him, because of COVID and other things, the state wouldn't reinstate his license for months. So that's what dropped him. And now the gentleman who's the president of the Builders Association offered his services. We've agreed to him. I've never talked to the man. I don't know that Mr. Hirschfuss has, or his partner, Mr. Cull, but I don't see any reason that he can't serve. And frankly, I don't understand the reluctance to resolve the case in accordance with his own contract. The complaint filed could have done a bunch of things. As far as I'm concerned, I just don't get it. If you look at the letters, my letter of the 28th of July, his letter early in the morning of the 29th, which refutes it, and then followed by other letters that are between him and Mr. Hoffman, Mr. Hirschfuss and Mr. Hoffman, I don't think there's any question that the court's decision below stands. It's in accordance with the law. She didn't abuse her discretion. I don't believe he is foreclosed from bringing the claim of lien because it's part of the contract, which is subject to the arbitration. The court could only dismiss his complaint on the basis that he didn't seek arbitration, which is what she did. Therefore, since the arbitration clause says anything arising from the contract, he has all the rights under the contract, including the portions of the contract that talk about lien, he'll have those rights. I don't believe the dismissal with prejudice impacts those. And I stated on the record now, if the subsequent counsel gets up after this case is over and makes the argument, the transcript from this court will be available. I am sure Mr. Hirschfuss knows how to order a transcript. If the court has any questions of me, I'd be glad to answer.
All right, we have none.
Thank you, Your Honor.
Rebuttal.
So I think it's important to address two issues that Mr. Cohen addressed several times over and over. He tells this court what Mr. Hirschfuss could have done. He's wrong on 2 points to that. And here's what they are. First of all, the statute doesn't require. If my client chose to sit around and do nothing, which by the way, they didn't. Let's just assume they did. The statute gives you a ceiling. You've got 1 year, file your case, and then move forward. It doesn't say, here's a grocery list of things you might want to do while you're waiting. It doesn't require that at all. The other thing, and again, repeatedly over and over, he's telling you what I could have done. What he doesn't tell you is that in the interim, dealing with the 3 attorneys, there was an effort made not only to solidify what these alleged issues are, which no one would come up with. And by the way, this Hoffman letter that Mr. Cohen represents to you, well, Mr. Hoffman talked about the dollar issue. Well, what happens under the statute, if there is a request made for information regarding who your subcontractors are and what have you, there's a way to do it. There's a process. When he requested that information because they were paying us a percentage of labor and material, not only did we comply and turn it over, we recorded on the property. Okay. And by the way, the statute's philosophy is, why do you do that? So that a subcontractor doesn't get hit with all these claims. I'm sorry, the homeowner doesn't get hit with all these claims from subcontractors and doesn't know what to do. So that's a philosophy. So the statute says the builder must, upon request, you not only do tender it, then you actually record the instruments. We did. And that's how they took all that information and went and they paid every single subcontractor. So what they did was the only person left with zero was my client. Everybody else got paid. There was a dispute that arose with the cabinet maker because these were custom cabinets. My client paid a portion of it. And the cabinet maker called my client and says, they're trying to negotiate it down. You're going to have to come up with the difference. So, I mean, what she did was she was negotiating with all these subcontractors. Maybe she was effective, maybe she wasn't. It doesn't change what we're entitled to. So we didn't just sit around. We followed the statute. We recorded our instruments, and that's what you're required to do. So Mr. Hoffman's letter asking for information, we did it pursuant to statute. Okay. The other thing that Mr. Cohen says several times is that he says, you know, Mr. Hirschfuss could have asked the court, okay, why don't you just stay the proceeding? Put aside the fact that that was one of the things that we addressed to the court in summary disposition. I read for the court specifically what Mr. Cohen's position was, their prayer for relief. Wherefore defendant requests that this honorable court grant defendant's motion for summary disposition pursuant to MCR 2.116C7, order that the case is dismissed with prejudice and assess costs and attorney fees against plaintiff for the failure to comply with the binding arbitration provision term of the contract and causing defendant to incur unnecessary costs and attorney fees. What the court did was grant the relief that they wanted, not the cost and attorney fees, but granted a dismissal with prejudice. So yes, I'm sure Mr. Cohen and his client are abundantly happy that the court was swayed by their argument and said, oh, arbitration, we're done. The problem with that is it doesn't provide the statutory relief that we are entitled to as a matter of law. And I just want to end with this. It's nice, you know, we stand up here and we argue the positions, but this was real time. Mr. Cohen didn't have the benefit of the real time. I did. First, he tells you my law firm drafted the agreement. Then he says, these are the things you get online. I'm not sure which one it is. And frankly, it's irrelevant. Most of the construction contracts, by the way, do carry the binding arbitration clauses. The AAA has, even for homeowners, they have specific arbitration rules that deal just with this, so that a homeowner literally can come in and with very little effort, with very little dollars and cents spent, is able to get this matter resolved. But that's not the statutory lien. That takes care of money issues, damage issues. You build a bad foundation, I have a bad HVAC system. You can address all that, not your lien. A arbitrator, there's a law that allows the arbitrator to pass on the validity of a lien. We know there's law. If I ask for a $100,000 lien and it's determined that I did not have a right to more than $75,000, if I overinflate my lien, a court has the absolute right to strike my lien. That's a punishment. There's case law that allows an arbitrator to pass on the validity of a lien. I won't get into the fact, can they say if it's overinflated, but there's case law certainly that allows it. We're not talking about the validity of a lien. They're not addressing that. They've never addressed that we didn't have a valid lien. All they're saying is go arbitrate, and that you can't do. Again, statutorily, he has given you nothing of any substance that says that I shouldn't be entitled to my year and to file in the county. And by the way, that same statute doesn't say, and plaintiff, when you file your lawsuit asking to foreclose on that lien, the next thing you should do is ask for a stay of proceedings. It's not in the statute, and there's no custom. What happens is in the ordinary course, business attorneys get together, they work it out, they'll do a step in order. There was none of that over here. There was offered. We offered. A little disingenuous, Mr. Cohen comes back and says, I offered it. But I told Mr. Hirsch he had to do certain things first. Yeah, that's the problem. It's what he wanted in exchange for that stay. And that was an issue. Just want to tell the court also that it's interesting when you look at the stay of proceedings that they disingenuously say, why didn't he ask for it? I don't have. Why didn't they ask for it? The statute doesn't say if you file the lawsuit, you're good to go. It says you got to take action within the year or else. And if the legislature intended it, and even if Mr. Cohen is 100% right that I can order this record and I can say to some court down the line, look, he agreed to it. His agreement to it in an oral argument in the Court of Appeals wouldn't probably carry a whole heck of a lot of weight in front of a judge with a new attorney who's saying, wait a minute, I don't care what he said or didn't say. It's either statutorily allowed or it's not allowed. He doesn't have the right to override what that statute says. So unless your honors have any questions, I appreciate the time that you've afforded us. And I do agree with Mr. Cohen, not on many things, but certainly on this. Thank you very much for hearing us today and literally squeezing us in so that tomorrow we can take care of our religious business. Thank you so much.
I think we understand the issue and the case is submitted. That I'm going to call item number 1, docket number 356-380, People of the State of Michigan versus Jeffrey Deshawn Watkins.
Good morning. May it please the court, Jonathan Simon on behalf of Mr. Watkins. I believe my brief clearly sets forth 3 reasons why this matter should be reversed and remanded to the Tuscola County Circuit Court for further proceedings, and I would reserve rebuttal. Thank you.
Thank you, Mr. Simon. Appreciate it.
May it please the court, Erica Wally on behalf of the people, Assistant Prosecuting Attorney from Tuscola County. Since the time of the filing of my brief in May of 2022, the law has changed regarding whether SORA, the new SORA is
It's
punishment.
punishment. right?
Yes, so Lyman was decided in June of 2022, and then Nunez followed in July of 2022. I think both of those holdings make section 3 of my brief pretty much off point at this point. However, I would still argue to this court that this case is distinguishable from both Nunez and from Lyman, because in the present case, you have a defendant who had actual knowledge of the SORA requirement. In Lyman, that was not a plea-based conviction, and the issue there was whether someone could be subject to SORA for a non-sexual
Right.
conviction of unlawful imprisonment that didn't deal with a minor. And then in Nunez, it was a plea-based conviction, but the defendant in that case wasn't notified of SORA until almost a year after imposition of sentence. In the present case, the defendant was notified of the SORA requirement by the people at the time that the complaint was filed. The complaint in this case was filed on May 8th of 2019, and the defendant was served a copy of that at his arraignment on May 9th of 2019. I was present at that arraignment. I can attest to that. People's Exhibit 1 is the complaint, the felony complaint in this case. If you'll notice on pages 3 and 6, SORA notices were provided to the defendant at that time. Again, the defendant was provided notice of SORA and the felony information, which was provided to the defendant or filed with the circuit court anyway, and provided to the defense attorney on July 11th of 2019. Again, pages 3 and 6, and that's People's 2 attached to my brief, provide SORA notices, and then the defendant pled in June of 2020. So the defendant had 13 months of actual knowledge of the SORA requirement in this case. I think that makes this case significantly distinguishable from Nunez and from Lyman. I would argue that the actual knowledge the defendant had cures any error in the plea taking process based on a failure to advise the defendant of SORA, and that the defendant's plea should be upheld and the error should be deemed harmless due to his actual knowledge.
So let me ask you, what is happening now in light of Lyman and Nunez?
So what is happening now in our courts or in
Right.
this case?
During the time of a plea. So the rule requires the court to advise the judge to personally advise the defendant of punishment, correct? And it speaks in terms of prison, jail sentences, and then also lifetime electronic monitoring. And it doesn't say anything about SORA, but now we have this case law.
Right.
So what is happening on the ground today as a result of that, if
So-
anything? Or are we just relying on, we gave you a complaint, we gave you an information, and on there is listed, please be advised that you may have to register under SORA, or that this is a certain type of offense that requires registration under SORA?
To be honest with the court, I became aware of Lyman and Nunez yesterday, so our courts have not taken this into full effect. However, in my circuit court today, I actually have a case that someone is sitting in for me and taking a plea, and I did advise that this be advised to the defendant at the time of the plea. However, there's no way that our circuit court judge could have known 3 years ago.
Who could have predicted?
Right, that this
Right.
would change. And I do
Right.
think that that's what makes this case different, is he did have actual notice. If it was like Nunez, where he wasn't given notice until a year after the day of sentencing, I think it would be different. But here there was an actual notice component, I think, that would cure any error and make it harmless in this particular case. And that's what I would argue to the court. If the court doesn't find that argument compelling, I would ask the court to just simply issue an unpublished opinion so that I can take leave with the Supreme Court. Lyman
Right,
has had
we know
leave,
that, yes.
and I'll be piggybacking off of that. if
Right,
that's the
and the
case.
prosecutor has filed a motion for a cross appeal, but that's pending, but nobody's challenged Nunez.
Correct.
And we would still be bound by that decision.
And I think that Nunez is going to be bound by whatever is decided in Lyman, because Nunez
They can
was based on
overrule it.
Lyman. Yes, so
Certainly.
I'm interested to see and hopeful to see where it's going to come out in the end.
Okay, all right.
Unless the court has any further questions for me.
I see none. Thank you.
Well, I don't know that I really need to rebut, but I just want to make one point. And that is that Ms. Wally kept saying, he's been notified, he's been notified, he's been notified. Well, actually, maybe his attorney wasn't notified, that his attorney might have been served with a complaint, his attorney may have been served with an information. And under agency law, that may be sufficient to provide notice to the agent, the principal, by service on the agent. But I think criminal law requires more than that. And of course, now the court rule requires that the court, in fact, personally provide that information to the defendant. And so I believe that any issue involving notice is also specious. Thank you.
All right.
Thank you.
Thank you both. That matter is submitted. I'll call item number 2, docket number 358642, Rosalind Russell versus Ear, Nose, and Throat Consultants.
I think plaintiff may have stepped, who is pro per may have stepped out just for a moment.
All right.
So best to call the case in a little bit.
Can we see if we can get her? Because of the recording, it's more expeditious to proceed. All right, so, okay. All right, so we are going to pass on item number 2 for the moment, and we will move on to item number 3, docket number 358751, Robin Novad versus Pauline Properties LLC. Please correct me on that pronunciation.
Your Honor, Mark Merlanti for the appellant Pauline Properties.
Mhm.
Like one of my predecessor counsels today, I became involved in this case midstream. And I became involved in this case after the seminal moment in the case, which of course is this stipulated order entered on November 23rd, 2020, which I have briefed as a procedure to handle a number of items. First, of course, returning the property to Pauline Properties. It's a quiet title. The title of the order really cannot be ignored. It is stipulated order quieting title and setting procedure for closing the case. That's a bit of an unusual title, but it's, when you look at the order, it makes perfect sense as why it was stated that way. And what's important, and of course I had to learn this coming in midstream, was that the order was in the context of not only a settlement conference, but motions filed by counsel for summary disposition on the same argument that's raised now in response to this appeal, which is you need to elect your remedies as a party that is the seller of land contract. Are you going to forfeit or foreclose? And that's the context of the stipulated order. And the stipulated order itself has a lengthy preamble about extensive discussions with the staff counsel and this pending motion. So when we talk about election of remedies, about a forfeiture or foreclosure, the real election of remedies here was the stipulated order itself. That is when the plaintiff, Mr. Renaud, elected a remedy to, instead of proceeding with his motion for summary disposition to force the selection of remedies, he chose the stipulated order. So it's a contract made by attorneys and approved by a court with participation from the court. And I would argue that's a really high bar to argue that a contract you made is no longer enforceable. So that's the context. Now, the order itself is fairly easy to follow. It has separate paragraphs that are in a chronological order regarding returning the property. And the second part of that is that Mr. Renaud had to cooperate with returning the property. So we simply drafted a quitclaim deed and it was recorded. So that's step one of the three steps. The second step was an appraisal. And the third step was damages. And one of the orders that I drafted, and discussed with counsel, was that the appraisal wasn't being done timely because during COVID, it was very hard to get real estate appraisals performed at all, if not timely. And one of those stipulated orders expressly references, and it's at my appendix 4, there was 2, I drafted both of them to give Mr. Renaud more time to get his appraisal performed. We needed it, he needed it, because that was going to be critical to damages. But one of these stipulated orders literally says that the parties are considering damages, the defendants, my client's damages, and delaying discovery. And that's in one of the orders that said, let's get more time for the appraisal to be performed. So that's, again, part of the context which followed the order. I mentioned the context before the order, which was a pending motion for summary disposition, asking the, in this case, the counter plaintiff to elect his remedy. Well, I don't disagree with that. It was elected because the agreement was made in the form of a stipulated order. So the context can't be ignored. And then you have to look at what did the trial court then do? And again, this is not the same judge that signed the order. And I don't have to tell this panel that judges retire and a new judge takes over. And sometimes it's hard to catch up, just like I had to catch up in this case. And so this trial judge makes a ruling that disregards, without any explanation whatsoever, 2 of the steps in this order, and I call them steps, but they're just components of the order, which is an appraisal and then a damage claim. Now, the logic in the court order, I've been very critical of that logic, but even setting that aside for a moment, this panel understands that when a court has to review a finding, interpret an order, which is a contract, they have to enforce that unambiguous contract as written unless they find an exception. Or I should say it finds an exception. It's one judge. There was not even an analysis of that. There were findings made without any support, but the analysis that's required really for contractual construction, because it's a consent judgment or stipulation, is deemed a contract. There's plenty of case law on that. I've cited it. I don't have to repeat it to you. It wasn't even attempted. Counsel in his brief acknowledges at page 14 that they agree there is no fraud, mistake, or ambiguity in the underlying order. But the problem is, according to counsel, is that it would be incongruent with Michigan law regarding forfeitures and foreclosures to overturn the court's decision. Well, of course, obviously that's a self-serving argument, but it ignores the stipulated order that that very counsel agreed to on behalf of his client. And so you're taking a very bad decision from a trial court that does not contain the analysis needed regarding ambiguities, unconscionability, that type of thing. Doesn't even mention it in his opinion. And then counsel indicates that, well, he didn't follow the law on forfeitures and foreclosures. Again, just joining with the sentiment that we can simply ignore. Excuse me, that is my client. So, direction. But you can't simply ignore what the law requires when you review a contract. In this case, that contract was a stipulated order. And and counsel agrees that there was no fraud, mistake, or ambiguity in the order, but simply that it's incongruent with Michigan law, which simply sets aside the agreement they made. Now, I do want to, so I'm not going to argue the lack of findings on ambiguity and unconscionability because that's been conceded. Unless you want to hear from me on that, I will move on to something else. The court order says that the stipulated order is silent regarding whether it's a foreclosure or a forfeiture. And that's true because it was neither. It was an agreement to return property, have it appraised, and argue damages. It doesn't have to be one or the other. This is freedom to contract. This is a party making an agreement or parties making an agreement in litigation, which is often designed to save attorney fees and various other things that people are allowed to do. And that was ignored by the court by simply indicating it doesn't reference foreclosure or forfeiture. The court then says it's silent regarding that the appraisal will serve as the purchase price. Well, what the court doesn't do is tell you then what is it for? What is, I don't use this very often, but there's something called Occam's razor, which is that the most logical answer is probably the answer. And so we have here a court saying, well, it doesn't literally say the appraisal will be used as a substitute for a sales price. But the court doesn't say then what is it for? Counsel doesn't say what it is for. So what is it for? Well, I go back to the title of the stipulated order. Quieting title and setting a procedure for closing the case. You can't simply ignore the procedure which is in the order, which is an appraisal and then a claim for damages. It's really not very complicated. But the court, I would argue, was simply finding a path to get to a result the court wanted to get to, which is, well, it doesn't literally say the appraisal is to set a sales price. But again, he doesn't say that what is it for? Doesn't hold a hearing so the litigants can explain this. There was not a single hearing in this case. It was all decided on motions. Then we have the finding is against the case law. It says, look at the whole. That was what I was really just arguing, is you have to look at the whole when you interpret a contract. And I believe the trial court did not do that. The forfeiture statute, that the judge found this was a stipulation for a forfeiture. Again, the stipulated order doesn't even use the word forfeiture, but it doesn't contain things that a forfeiture would contain, which is a redemption period. It doesn't set the arrearage amount to be paid during the redemption period, and title is immediately given to my client. None of that is consistent with a forfeiture. And keep in mind, I want to bury the lead here, but maybe I did, is that when we were arguing to the trial court, counsel didn't argue that the stipulated order was an order for a forfeiture. What counsel did was refile the motion filed before the stipulated order was entered, which was elect your remedy. You need a forfeiture or a foreclosure. And there was two arguments added to that motion. The motion actually had the date of the prior motion 1 year earlier, the old caption, so my name wasn't on it. But it did have two new components, even though the cover page wasn't different at all. And the two new arguments was, this is a double dip. You can't get real estate back and get a deficiency. Well, that might be true under a foreclosure, but it's not true under this order. That's the agreement the parties made. And there's nothing unlawful about the agreement. That's one of the exceptions to enforcing a contract, is something would be unlawful. Well, there's simply nothing unlawful about two parties agreeing. And keep in mind, the plaintiff had made 10 payments out of a 3-year contract. I believe that that's why probably redemption was not that attractive, because it wasn't going to be able to make the payment anyway. But the double dip argument has to be placed in the context of the order, which it wasn't. And it has to show that there's something unlawful there, and there simply isn't anything lawful about someone getting property back from someone who was buying it on a contract for $350,000 and hadn't made payments and hadn't paid taxes and insurance. There'll be damages there. And the other new argument was that failing to elect a remedy is a failure to mitigate. Now, I don't agree with the argument, but it was rendered moot by the stipulated order itself. So what happened was, after the appraisal was finally done, instead of moving toward damages, counsel simply refiled his motion. And incredibly, the judge agreed, finding that the stipulated order was an order for a forfeiture, doesn't support it with findings that make any sense, which I've just reviewed, doesn't support it by following the law, which says to make an exception to an unambiguous contract, which counsel agrees is unambiguous. You have to make certain findings. None were even made, and none were even considered. So the order is clear error. Now, we had filed a response to that refiled motion seeking damages, which, whether it's by summary disposition or an evidentiary hearing, and we don't disagree, and we never briefed that we were trying to foreclose summary disposition. That's never been our position. I would argue that my request for damages could be summarily disposed of, but because of the court's ruling, my request for damages, which was filed in response to the motion, the refiled motion for summary disposition, that was simply eliminated with the order saying there will be no damages, no attorney fees. So what I would ask this court to do is either order the damages that I've laid out in the brief, supported by documents. It's simply unpaid principal, calculated interest, taxes paid by the seller that were the buyer's responsibility, and insurance. But if you want to remand it for a hearing on that, that's fine too, but we are entitled to those damages. I will reserve rebuttal and take any questions you may have. Thank you.
Your honors, may it please the court. My name's James Randall Witham. I'm here on behalf of the appellee. His name is Robin Vinod. This was a property transaction that happened all the way back in 2015. I won't go through all the facts, as I'm sure this court is well aware of them. But first, I would like to note that the appellant in this case, Pauling Properties, sought equitable relief in their counter complaint, specifically pursuant to MCL 600.2932. That's going to be in paragraph 3 to its counterclaim. And as such, under subsection 2 of that statute, it governs and it cannot seek relief greater than that afforded under both a quiet title action and a land contract forfeiture. Specifically, if you go to MCL 600.2932, subsection 2, it states, no action may be maintained under subsection 1 by a person for the recovery of possession of premises which were sold on land contract to whom relief is available under subsection 1 of section 5714, which is the current section because 5634 was subsequently repealed. So accordingly, under MCL 600.5714, Pauling Properties recovery is limited to possession and title only, if that's what they're seeking, and that's what they were. They were seeking a quiet title action. They were considering a smattering of different things. They alleged breach of contract, quiet title, so they're intermingling different causes of action. However, unfortunately for them, their gambit of remedies was limited, specifically when they asked for quiet title. Now, the parties wrangled over this case for a while, and there was a stipulated order, and you won't find in that stipulated order any express provisions indicating that my clients waive any rights that he may have under forfeiture or foreclosure. And there was also argument meant about the contract. It's essentially a land contract that's before this court. So let's go to the land contract and figure out what the parties are supposed to do when there's a dispute or there's an issue. And specifically in paragraphs F and G of the land contract, it states what to do. You can do a forfeiture. They're under subsection G. It says forfeiture and other remedies as well. And it specifically says depending on the remedy sought. In this particular case, you have two different things. You've got a forfeiture and you've got a foreclosure. And there's separate rules for each one. And this is what we argued from the beginning. I still don't think they adequately addressed how to, which one they were ultimately going with. But at the end of the day, this court is left with a stipulated order that was entered into between the parties. And much like many stipulated orders, this was meant to try to narrow the issues that are going to be ultimately tried before this court. And the court ultimately found that pursuant to this, they're going for the forfeiture route, which was stipulated to in the contract. Did it say forfeiture? No. Did it say foreclosure? No, didn't, right? But what it did say is that my client is going to deed over the property to the appellant in this case. And that's what happened. So from a practical standpoint, what is this court left with? Even if this court were to consider remanding this, there's no property to give back. You can't put the bullets back in the gun. They've already been fired. You can't, give the property back. And then what do you do? Go through a foreclosure sale to ascertain the true value of the property? Because they still haven't selected, the appellant still hasn't selected to this day whether they want to do a foreclosure or a forfeiture, right? And that's typically how you do land contract cases, right? Like they either foreclose on it or they'll go to the district court and do a forfeiture action. But the court's not left with this. It's left with a complaint that wants everything and doesn't want to have to take responsibility for, in this particular case, the specific request for quiet title and ramifications that happen when you plead and you allege a quiet title action in terms of the limitations of the remedies. So the other issue, of course, is going to be certain inalienable rights, such as if they want the foreclosure route, there's a statutory period, just like in a forfeiture action that opposing counsel argued. There's certain things that have to transpire that just simply didn't happen in this case. In this case, the parties agreed. They agreed to a scheduling order. They agreed to a disposition of the property. Nobody agreed to waive arguments. Nobody agreed to waive defenses. Nobody agreed to waive claims. And when you look at the stipulated order, you won't find any express waivers about that. So in summary, from a legal standpoint, the appellant just simply doesn't have a cause of action. Could the trial court have articulated, its findings of fact and conclusions of law? Perhaps, but it got to the right decision regardless. But moreover, what the appellant is requesting this court to do, it just simply can't do it because the property's gone. It's been deeded over. It hasn't gone through foreclosure. We're not going through statutory redemption rights. None of that stuff. Instead, the parties are bound by the agreement they entered into in this case and all the repercussions that go with it. Thank you.
No further questions. All right. Thank you. Rebuttal?
I certainly agree. Parties are bound by their agreement and the repercussions of it. That's the whole point of the stipulated order, which I think has been roundly minimized by counsel. He's engaging in the same exercise the court did, which is to look at things in a vacuum and ignore the context. Now, the beginning of the argument was some statutory references. I don't know they were briefed, so I do not have a response to that other than I think the stipulated order controls. I'm not familiar with those. I'm familiar with the statutes in general, of course. I didn't think they were briefed, and if they were, I apologize. But the reference to 657.14 is the summary proceeding statute. That's a district court statute. This was a circuit.
Sorry, can you just speak up just a little bit?
I'm sorry. I'm struggling with the heat in this room. The district court statute, the 600.5714 is part of the summary proceeding statute. It's for land contract forfeitures and eviction matters. And I'm very familiar with it. And while that does typically deal with possession, that's what you're doing in summary proceedings. This case was filed in circuit court. The complaint does ask for money. The first subsection of the wherefore clause of the counter complaint, I should say, is asking for the entire balance to be paid. Again, this complaint will win no awards for clarity. Okay, there should have been an election of remedies at some point, but that's the purpose of the order. As I said at the beginning of my argument, the election of remedies was the stipulated order. So the plaintiff cannot simply argue you must elect your remedies time and time again and ignore this order and then file the same motion again after the stipulated order was entered. And we're talking about doing appraisals. And we're talking, one of those orders said, we will discuss damages that the defendant has. The trial court then gave a gigantic gift to the plaintiff by making this ruling. And so now the plaintiff has completely changed its argument to elect remedies to, oh, the district court was right, we have a foreclosure. I'm sorry, a forfeiture. They never argued that it was the stipulated orders of forfeiture. They just simply refiled the same motion they filed. Why? I have no idea, other than they have a new judge. What did they have to lose? So there's no rhyme or reason to why you would file the same motion that you filed before the stipulated order and file it again after the stipulated order is entered. It says, counsel indicates the stipulated order has no waiver of rights. Again, that is picking and choosing very carefully, but in a vacuum. It says procedure for closing the case. Talks about an appraisal. We did 2 orders after the stipulated orders entered to give Mr. Vinod more time to get an appraisal done. So when the court says, well, you didn't have to do an appraisal, I beg to differ. Okay, maybe the stipulated order wasn't drafted perfectly. I don't think we have a perfection standard here. You have to look at the thrust of it, the context, the document as a whole. Counsel's brief cites that you have to give meaning to every phrase, every word. That's what we're trying to do. He's no longer trying to do that because the circuit court didn't do that. The argument that the property is now gone and therefore we can't follow the order is simply ridiculous. That's why there was an appraisal to be done, because the property did not get sold to some third party. It was simply transferred back to Pauline Properties. The order says regarding the appraisal, you must cooperate. That's an order to Pauline because it's now in possession. So of course they have to cooperate so that Mr. Vinod's appraiser can gain access to the property. Doesn't make it unimportant. It's just a pragmatic part of the order. This order is pragmatism at its best. It may not be drafting at its best, although there's been no explanation from the circuit court as to what the order means if it doesn't mean what I claim it means. There was these very technical arguments that it doesn't literally say the appraisal is to determine a sales price, and other similar arguments without giving any deference to context and without explaining then why are these words there. The circuit court order and the argument now basically takes 2 sections of the order and makes them irrelevant against the case law cited by counsel. Again, I will close with the parties are bound by the agreement and its ramifications. I agree with counsel on that. And so I would ask for either this court to enter a judgment in my client's favor in the amounts laid out in our response and in the brief, or remand for damages. Thank you.
Thank you.
Thank you both. The matter is submitted.
Annika, is it hot in there?
They just turned up the air, I think.
Oh, I was gonna say, because the vents are on the windows there, you just turn them down. This little, turn them to 0.
All right, we're going back to item number 2. Do we have Ms. Russell in the courtroom? Yes, okay. All right, item number 2, docket number 358642, Rosalind Russell versus Ear, Nose, and Throat Consultants. You may. Ms. Russell? Okay. You're going to have to come to the podium and you can lower it. Could you help her lower the?
I can stand for a while. I can stand for a while.
Well, we can lower it for you if that'll be helpful. Okay.
Can you hear me now? Can you hear me now?
Can you hear Judge Servito?
Mm-hmm.
Okay.
I can stand for a minute.
No, you're fine. You're fine. Go ahead.
Okay, I am in, my name is Rosalind Russell, and I'm in pro se for myself, okay, against Watkins and Associates. And I just found out about it 2 days ago, 3 days ago from the e-file. I was at the e-file. I received no notice of anything. But I do have the paperwork that I put in the Court of Appeals before
Okay,
for the errors that the court had made with McKean and Associates, okay? And where do I go from here? I'm not an attorney. Do I tell you what the arguments are, or?
right. Well, we've read your brief. So if there's something that you'd like to emphasize in your brief, that would be fine. Or if you would like to tell us, our role here is as an error correcting court. So if you would tell us what your claim is that the trial court
Okay, I'm
erred
coming
in
in
doing
because the
here.
court erred 7 times.
Okay,
Okay,
right. We have your brief, so
but you didn't get the last one.
your reply.
No, ma'am, it was the trial should never have been dismissed. As the court trial had already been set. The judge retired, and then he set my court date, then retired. Okay, and I guess pass it on down to somebody else who's not familiar with my case. And the opposing counsel did use every trick in the book to get me thrown out, even when they dropped my case. Okay, and I asked why did they drop my case? The judge originally said it was an emergency. What do you call it? An emergency dismissal or whatever. You know that he couldn't do that. He couldn't drop my case on an emergency. You know, just like that. And the only thing they did, then the judge denied it. Okay, and then he come back and dropped the word emergency, and the judge granted it. Okay. And as I got 7 to 8 errors in which the court erred against me, you know, as far as McKean and Associates are concerned, you know, like, you know, and I'm all messed up and they're not, you know, and I got, even the surgery, you know, consent form. I think that's argument number 2. Argument number 3, that the trial erred, allowing the parents to withdraw. And they didn't tell me any reason that they withdraw. They told me, oh, you would have to come down. You ain't got to say nothing, anything like that. And then argument number 4, that they admitted that they got what you call an expert witness to come in from Maryland. You got a lot of expert witnesses in Michigan. You got to get an expert witness from Maryland to come in. And he said that Dr. Stone and his godlike walking on water appearances or whatever, the way he put it, you know, he erred. He never should have taken my thyroid out or whatever, you know, never should have performed surgery on me at all. And then it aired also with adversely with them with drawing, you know, it adversely affected my lifestyle and my way of living or whatever, and which is very, very, it's going downhill every day, okay? And then it breached the American Bar Association rules and everything. But I searched that. I had some friends of mine searching, and no one would take my case. And Mr. Buyer came out in the courtroom and told me, said, I'm gonna put a lien against your house. You're not gonna win. Nobody's gonna take your case. And I didn't believe it. And so I called 32 attorneys, okay? And 32 attorneys would not take my case. And I was just wondering, you know, why, you know, wouldn't an attorney take my case? If it's something that's in the computer, it says case ongoing or case, what is it? If 32 people would not take my case at all, you know, so I had to, you know, fight for myself. You know, I'm a 77-year-old woman and I'm going to fight for myself, and my life means something to me. You know, my life matters, and I'm going to fight all the way down the line of whatever I have to do. And then also I've got the case laws are there. Okay, the United States Constitution, which says I am entitled to go to trial. You know, that I am entitled to tell 12 jury and 2 alternatives what happened to me and what was done to me. You know, and maybe to other people too. I don't know. You know, and like I said, I'm not an attorney, so I don't know all the correct words to use. But I'm just telling you that it's something very, very, very bad happened to me, and I'm in the shape that I'm in now. I'm in a wheelchair. You know. And like I said, I can't stand for a while, You know, my voice doesn't go over the microphone was, you couldn't hear me at all, you know, and I'm just sitting around, you know, this is my last chapter of my life, you know, and I was working, I was dancing, I was going out with friends, everything. I don't do nothing now. I mean, at all, because these, Mr. McKean and Associates, you know, they were all gung ho because Jeffrey Feiger gave them the case. Okay. And they were all gung ho. Oh, you're going to win. We're going to do this. We're going to do that. And all of a sudden they dropped my case, you know, with no reason. They didn't even tell me why. I kept asking and asking. No one said anything to me. They wouldn't even talk to me, you know. Then I get little nasty conversations on the phone from the attorney, you know, you aren't going to win in the appellate court anyway. No one's going to take your case. I'm going to put a lien on your house, just all kind of stuff. And I've suffered. I am suffering now, you know, and I want my day in court. And so, you know, and I think I'm entitled to, you know, my day in court. You know, everybody else get a day in court. You know, what's wrong with me having mine? You know, and the last thing is that they said that the word, they use the word admitted. You know, they sent me some paperwork and wanted me to read the paperwork, and I read it. But they wanted me to sign it, but there was nowhere on any of the paperwork to sign. No line, no little X, no nothing, you know. Then they sent it to the judge and said, that's like me admitting that I did something wrong when there was no place to sign, and they even didn't stay silent. Okay, I said, send the paperwork back, and they sent it back. The judge made them send it back, and I signed the paperwork. I admitted to nothing because I'd done nothing wrong. Wrong was done to me. And so I'm standing here now, and I want my day in court. You know, I want people to hear, you know, what's happened to me, you know, and how it's happening to me, you know, and what's going on. I may not be the only one. Can somebody just walk into a hospital with some paperwork and say, okay, we're going to do this, we're going to do that? No, you know, you just, that was done to me. And then also the doctor and I argued, which was my mistake. You don't argue with a doctor in the operating room, you know, but I did. I told him, I said, I don't want this, you know, this is not what we agreed to. I wouldn't insult other specialists. I got second opinions on it. He said, no, you start at the bottom and then you work your way to the top. You know, I was operated on because of money, you know, that's what it amounted to, you know, because he wanted the best money. And so I called all different doctors all over the country, Mayo Clinic, everywhere, and asked them, what is the procedure, you know, for what happened to me with the thyroid. They said, well, you start at the bottom with an endocrinologist and find out what exactly is wrong. You work your way to the top. Then if it's operating is necessary, fine. If I had cancer of the throat, you know, that's fine. You know what I mean? They say that's the best cancer to have. I didn't have cancer. All I had was a knot on the side of my throat, but it was easier for him to get the money for taking my whole thyroid out. Okay. Why? You know, when I called other doctors, they said, because it takes a longer time to cut off the little lobe and tie off the blood vessels or whatever. And then, you know, it's another, it's less money, but it's a good procedure and I'd be okay. I sound like Froggy on The Little Rascal. I can't call, if I turn my head away from you, you can't hear me. Your vocal cords go like this. And when you talk, they do this. My vocal cords are like this. I have POTS syndrome. That means I can't, if I stand up, I got to stand up for 2 minutes because my heart rate will jump up to 120, 140. Sometimes it doesn't go up at all. I mean, all kind of things happen to me. No one told me that the hormones, what do you say, control your whole body, your heart, your lungs, your skin, your everything, you know, and I'm just a shell of a woman standing here, but I'm still going to fight for myself. You know, whatever I got to do, I'm going to fight, you know, and I would like for you guys to give me my day in court. I don't care what Mr. Byers says. He even called me the other day on my phone and asked me, why don't you just drop the case? You aren't going to win anyway. Who does that? You know, I don't know anything about law. I just know how I feel and then how other people, we got a different world today. People do care. And this is the reason that I'm here. And, you know, I don't know what else to say except that I know you got the paperwork where the judges had aired on everything, you know, and, you know, and I'm not supposed to say anything. No, I got a mouth. It's a big mouth, and I'm asking you to let me have my day in court. And that's all I wanted. Whatever he says, I don't even care. I just
Well,
want to
all right, so let me tell you this. You will have an opportunity to respond. So why don't we listen to what they have to say and you can
Okay.
have a seat
Thanks.
and I see we have 3 counsel listed on the other side. Have you decided how you're splitting your time?
Yeah, but I expect to be brief. I don't think.
Just, all right,
I don't think there's going to be an issue with
All right.
that. May it please the court, I'm Daniel Byer. I'm counsel for the appellees, ear, nose, and throat consultants, and Michael Stone, MD. I've been involved with this case since its inception, so I'm pretty familiar with the circumstances. And if there's any questions the court may have about the procedure or any of the other issues, I'd be
I don't-
welcome to answer them.
I don't know that we have questions about,
So what I've heard from Ms. Russell at her presentation is essentially a rehash of what she has said for some time, is that she was unhappy with her counsel, she was unhappy with the representation, and that the withdrawal was inappropriate. And this has already been decided by this court. It's already been decided by the previous decision by this court concerning the request to admit. Her allegations on these numerous points have been brief, but I wanted to focus on the fundamental issue, which even today, Ms. Russell does not appear to grasp, and that is the issue of Dr. Morris's criticism that Dr. Stone should have referred Mrs. Russell to an endocrinologist that is a non-surgeon, how that would have changed anything. And Dr. Morris, whose testimony, I think it's page 85 or 86 in his deposition was included in the brief, states that I am only speculating, I'm paraphrasing, but I'm only speculating as to what this hypothetical endocrinologist would have done, whether this person would have overturned or changed or influenced Dr. Stone's decision to go forward with that surgery. He's speculating about that. And that's important in the context of some of the other procedural components of the case, which was, I believe, in December of 2018. The plaintiff, who had not yet withdrawn, plaintiff counsel had not yet withdrawn, and had identified an endocrinologist on the witness list, presumably to create this additional link in the causation chain that was required to prove a case of professional negligence or malpractice against Dr. Stone. But because of the withdrawal and because this endocrinologist was not produced for a deposition and was indeed precluded from being produced for any testimony pursuant to Judge Bowman's order, this important causal link was never made, thus making Dr. Morris's testimony inappropriate to take this case to the jury on the issue of Dr. Stone's negligence, whether this hypothetical referral to a endocrinologist would have changed any decision. And I might add parenthetically, and I believe this is included in the record, is that Mrs. Russell was referred to a surgeon, my client, Dr. Stone, by her primary care doctor, Dr. Mays, who did not refer her to an endocrinologist. And Mrs. Russell herself went to got a second opinion from another ear, nose, and throat specialist, Dr. Singer, who also, she advised him that Dr. Stone had recommended this total thyroidectomy. And that's included in the record as well. And Dr. Singer did not refer to her to an endocrinologist either. Finally, there is the unrebutted testimony of Dr. Borovic, Dr. Harry Borovic, who is the defense expert witness on standard of care, and he opined that the standard of care did not require a referral to an endocrinologist before proceeding with this total thyroidectomy recommendation, which was done on the basis of a piece of tissue that had not been confirmed as not cancerous and an increase in size on the other side. So the plaintiff has not presented any factual issue on the issue of whether an endocrinologist's involvement would have changed the outcome or changed the decision to do the surgery, because the plaintiff's expert witness had no criticisms of the technical performance of that surgery. And that's a segue into, I think, the final issue I want to talk to you a little bit about. This claim that is still being argued that she somehow did not consent to this procedure. And indeed, as this court is aware, there was a motion filed on behalf of Dr. Stone to strike this portion of the plaintiff's argument on this basis that her consent was forged and the like. And that's absolutely not true, as borne out by the signed consent that she signed, that's part of an exhibit to her deposition, and the unequivocal testimony in her own sworn testimony at her deposition when she indicated that was her signature. And, the court, I'm sure, is familiar with the Dykes case that was cited in the brief, which does not permit subsequent affidavits to overrule unequivocal sworn testimony such as that given by Ms. Russell in her deposition. So the nub of the issue is really a very simple one, Your Honor, Your Honors. The issue is that she did not provide a sufficient causal link to create an issue of fact, because there's no expert testimony that indicates any endocrinologist would have overruled or made a different suggestion than Dr. Stone made for this thyroidectomy, a procedure that she consented to and a procedure for which she obtained a second opinion on, which I note she's conveniently left out of her presentation today. And unless the judges have any questions for me, I'll do my best to answer them.
No questions.
I don't see any questions.
No.
Morning, Your Honors. May it please the court. My name is Jesse DePaul on behalf of defendant appellee Providence Park Hospital. The only point I think I wish to make is that it does not appear that Ms. Russell is challenging the trial court's decision to dismiss the claims as to my client. And unless the court has any questions, I think the issues have been adequately briefed.
All right, thank you.
Thank you.
Thank you.
All right. Ms. Russell, yes, you have the last word here. You have time for rebuttal.
As far as what Keen and Associates is saying, I got a second and a third opinion. I called doctors all around the country. I even called anesthesiologists and asked them, what should I do? How should I go about it? Okay. And then when I talked to Dr. Singer, he said, it's not necessary to take out your whole thyroid. And me and Dr. Stone got in an argument because I wouldn't sign the paperwork. When the nurse brought me the paperwork, the little curtains they pulled past, and she was asking me to sign the paperwork, I said, I'm not signing anything. I didn't agree to a total thyroidectomy. I agreed to, and it's in the transcript, it was a little goiter on the side of my neck. It was on my thyroid that they agreed to take off. And I said, well, what's this, take that off? He said, oh, well, it may come back in years and that's going to take it off now. I said, no, that's my opinion. I don't want it off. So he and I were arguing. And my niece, who's a doctor, was in the operating room with me. My sister was there. I called her in Las Vegas, Nevada, and talked to the anesthesiologist and asked them, I said, why do people just want to just take it all off? They said they don't want to do the work and they want less money. And as far as the endocrinologist is concerned, that's where you start at, because that's your thyroid. Nobody told me that your hormones could control your whole body, your hair, your eyes, your nose, everything. No one told me anything. And then here it says, did the trial court err in the forward surgery? I didn't remember signing anything. Like when you go to an operating room and if you're upset or excited or something like that, I don't know what they gave me, but I knew I drew a line through total thyroidectomy and I initialed it. And I said, you do it too. That's like giving somebody a date rape drug and say they're not going to rape you. Okay. I was given something and I don't know if I signed it or if I didn't sign it. But I know I drew a line through it and initialed it and then told him I wouldn't do anything because the nurse kept getting mad at me because she wanted to hurry up and get I guess, go along with the procedure at the hospital. But I wouldn't do it. I said, no, I'm not gonna do that. And then the doctor and the nurse that was in the room with me, my niece and my sister, they didn't hear the conversation, but they know that we were going at it. And then he just got mad and just snapped. He said, well, I'm gonna do a total. I said, no, I don't want that, you know. And then the next thing I knew, I woke up, I didn't have a thyroid. Okay. And I knew that I drew a line through it and I initialed it. And after that, I don't remember anything. I was still in the little waiting room area that they put you in behind those curtains, the whole bit. And this man did this to me. And when I went to see Dr. Singer, he said, no, it's not necessary to have your whole thyroid out. You can just take the part out that's affected on the left lobe.
Damn, you said that 3 times now. 3 times.
That's all.
Thank you.
And then later on, if it becomes infected or whatever, fine. No cancer, no nothing. He did the biopsy in his office, you know, and then I asked him, I said, well, what's going to happen to me? What's the side effect? He said, yeah, take a pill the rest of your life. That's all. You know, it's a hormone pill. That's all the information I got. But he sent my primary doctor a letter, a form letter. Thank you for letting me see your patient. He didn't do that. Some doctor in the emergency room gave me his number and told me to call Providence Hospital. They gave me Dr. Stone's number. And then he said nothing, not one word about what the side effects are. You know, like now, everything, if I put aspirin in my mouth, I look it up and what are the side effects and everything. And as far as the endocrinologists are concerned, I think that, you know, that if you got diabetes, you get tested for diabetes, you know, and they'll tell you rather than just jump up and give you some metformin or some insulin, you know, you get tested for everything, you know. Then they tell you, well, this is what can happen. This is what can happen. I got none of that. Not a thing, you know.
I think we understand. I don't think that we have any questions for you, so we appreciate. I don't think we have any other questions for you, but we appreciate you coming here today and advocating.
Okay. Thank
Okay,
you.
and we will submit the matter and we will issue a decision and it'll be sent to you.
Okay, thank you very much. I appreciate it.
Have a good day.
I'm through. I can go now?
Yes.
Oh, okay, thanks. Bye-bye.
Yeah, the case is submitted. All right. And with that, we're going to take a short recess. 5 minutes. Going to move on to item number 4. Oh, do we have Judge Cerrito? Is Judge Cerrito back with us? Okay. We'll wait for Judge Cerrito.
Your Honors, I do see that Judge Cervito's video is still off, so she's probably still not back from the break.
Okay, thank you, Sean. We might have come back a little early. All right. Are you all set, Judge Cerrito?
Yes, sorry. I had you.
No, you're fine, you're fine. All right, we're going to call item number 4, docket number 355-147, Ballard Management Company versus Robert Fosna Psychiatric and Rehabilitation Center, I'm assuming. All right, and we have only the defendant appellant endorsed for oral argument, so you have 15 minutes. Are you gentlemen sharing time or are you together? Okay, all right. Please proceed.
Thank you. Good morning, Your Honor. Robert Kerr, honorable panel, on behalf of the appellants. I'd like to take just a few moments to reserve for rebuttal if necessary. The facts of this case are.
The other side's not endorsed.
I apologize, Your Honor.
The other side is not endorsed, so it is just you.
No problem. Thank you. The facts of this case are somewhat straightforward, but they're also somewhat not straightforward. I know that sounds rather odd to say that way, but suffice it to say that the parties had a land contract in 2014. The terms of that land contract were set forth to the court. We believe that they are inconsistent. We believe that they are necessarily ambiguous. Be that as it may, there was a case that was started in the Macomb County Circuit Court to deal with that particular land contract. That was mutually dismissed in 2017. Why? It was dismissed because the parties were engaged in discussions associated with the purchase of property through a different means other than through a land contract. For 2 years that went on with discussions, agreements that were put together. One of them is an agreement that was produced, but this one is not signed. A number of bits of correspondence, promises back and forth. And it wasn't until 2019 that there was a refiled circuit court action seeking to foreclose upon the land contract. Originally, our clients proceeded in pro per. They were defaulted at the end of the year that was set aside. And on March 6th, the next year, a motion for summary disposition was filed under C10. Now, the scheduling order wasn't even issued yet. It was issued in April. The hearing on this particular matter took place 10 days after the scheduling order was issued, which provided for a period of time for discovery. The court made a decision, and one of the things that I quote is from page 4 of the opinion and order of the court: there's no dispute as to the validity of the November 2014 land contract. Well, that's not true. There was evidence that was produced, there was argument that was produced associated with a number of different matters, including the fact that the land contract appeared to sell property that was not in the purview necessarily of the seller to do so. That is Real estate 101. You cannot sell what you do not own. 2, there is an allegation that there was a breach on behalf of the land contract vendor, and that predated any alleged breach by the vendee. The concept of first breach is one that says you cannot grant summary disposition when there is a legitimate allegation associated with first breach that may result necessarily in the contract that is at issue being determined in one or more different ways. There is also an allegation of illegality of that particular land contract, of unclean hands, and a novation. The novation may seem a little different, but the fact of the matter is that for a period of 2 years, things were different between these parties. Things had changed and been altered, and the relationships had been changed through mutual respect and demand by the parties. You cannot just simply set that aside and say that that history does not exist, because it did exist. Under this particular set of circumstances, we believe that further discovery, in fact, discovery at all, would have been able to establish the fact that a part of the property that they allege that they owned, which one of the things that's interesting is in their brief, they say in page 7, quote, simply put, the November 20, 2014 land contract never included parcel 123151-005 as part of the sale, and as such is not part of the foreclosure action. But you look at the report of foreclosure sale, and it says, commonly known as 26755 Ballard Harrison Township, parcel identification numbers, and it's got the 004 and 005 numbers on there. So the report that they prepared for the sheriff belies exactly what's said in this brief. What's said in this brief is not true. They sold this other parcel that belongs to a different Ballard entity. One of the circumstances that is issued, and I apologize for reciting it at length in the brief, but it is such an established precedent that while there is discovery, while there is a possibility of discovery, it is inappropriate to grant summary disposition, especially 10 days after this court issued their scheduling order. The Court of Appeals recently said that only when no amount of discovery can rebut the proof submitted that the issuance of summary disposition is appropriate. The circuit court didn't deal with first breach. The circuit court didn't deal with illegality. The circuit court didn't deal with unclean hands. The circuit court came to an immediate decision to say that the land contract's not in dispute. That's not what was contained in the pleadings before the court. That was not what was contained in the argument before the court. And it is simply untrue. Fact of the matter is that there is a dispute associated with the terms of the land contract. There is a dispute regarding the relationship of these particular parties, and discovery will flesh all of that out. You cannot go and have a foreclosure sale of property that you don't own. And yet they included that in the report of sale. And most recently, the trial court, despite the fact that this court has jurisdiction of this case, the trial court allowed necessarily another, what's called a new judgment, to be entered in this case, said that that judgment can have immediate effect, even though there's no citation to authority. We filed a motion for reconsideration saying that there is no legitimate basis under the court rules or the statute to say that there's immediate effect. But yet she's denied that in the order that recently came out just the other day. The fact of the matter is, Your Honor, is that these particular parties had a number of different contractual matters going between them. The representation that was made by the trial court was premature. It was not based upon a lack of a material question of fact or law. As a matter of fact, even under the law aspect of MCR 2.116C10, there is cases that are replete in the brief, and I will not repeat them, that indicate that when this allegation is made and when there is substantial proof with the affidavits that were submitted, the court must submit that necessarily to the trier of fact. That summary disposition would be inappropriate. Now, I apologize. I've probably been talking too fast and I apologize for that. If the court has the panel has any questions, I would be happy to answer whatever questions you may have.
No, I think we understand the briefing. Thank you.
Thank you very much. Appreciate the time today.
Thank you.
Matter is submitted. We'll call item number 5, docket number 357415, Macomb County Restaurant, Bar and Banquet Association versus DHHS Director.
Good morning, Your Honors. May it please the court, my name is Justin Majewski. I represent the appellants, Macomb County Restaurant, Bar, and Banquet Association. I'm aware that the court has read the briefs and is very familiar with the issues in this case, so I will keep my remarks as brief as possible. I will highlight 2 issues and field any questions that the court may have. If I may, I would reserve 5 minutes for rebuttal. In this case, there were several errors that require reversal. I'm going to focus on the issue of standing and the issue of jurisdiction, and the appellant would rest on its brief with respect to the remaining issues. On the issue of standing, for more than 50 years, the law in Michigan has been that a nonprofit organization has standing to sue on behalf of its members to the extent that those members would have standing in their own right. It is not the law in Michigan that associational standing is in any way limited with respect to money damages. No such rule has ever been announced. Michigan courts have simply not addressed this issue. And so for this reason, what the state seeks is actually a new rule. But the bright line rule proposed by the state is not well suited to address the wide variety of cases in which an association could seek money damages on behalf of its members. For instance, a homeowners association might seek tax refund damages based on an incorrect property tax assessment, or an employee association might seek wage-related damages from an employer. These are examples of real cases which in our sister jurisdictions have been permitted to proceed on the basis of associational standing. But under the state's proposed rule, these cases would not have been allowed to proceed. The state relies on federal case law for its proposed rule, but the federal courts have softened their stance on associational standing in money damages cases over time. The initial rule adopted in Worth versus Selden was that associational standing was not available if individualized proof was required. Later, the Supreme Court softened that language to state that associational standing would not be permitted in money damages cases if the member's participation in the lawsuit as a party would be indispensable. Later still, the court explained that the limitation on associational standing in money damages cases is not a constitutional requirement, but merely a judicially imposed prudential limitation, leaving state courts free to craft their own rules. The modern approach among states is to take a more pragmatic, balanced approach. These states,
this is all in your brief. I'm sorry to interrupt you, but we saw the citation to the out-of-state authority and read the court's opinion and also have access to the federal precedent. So if you're just.
Respectfully, Your Honor, I was touching on something slightly different, which is the approach that some states take, which was not in my brief. So just very quickly, Washington, Illinois, and Kentucky allow money damages to be pursued by associations in limited circumstances. And so the association here would advocate for a similar balanced, pragmatic approach where it's not a bright line rule where you can never pursue money damages. Rather, a totality of the circumstances test on a case-by-case basis would be, if this court were inclined to adopt a new rule, that such a balanced totality of the circumstances test would be more fitting in this case.
All right, that's fine.
On the issue of jurisdiction, the Michigan Takings Clause states that the procedure for providing just compensation must be established by statute. And in the absence of such a statute, the state cannot take property. It's per se unlawful for the state to do so. And so the UCPA in this case clearly states that it applies to all exercises of eminent domain, that it provides procedures for the determination of just compensation, further that it provides for damages and for remedies. There's nothing about the language in the UCPA that would limit it to formal condemnation proceedings. That act recognizes de facto takings. And so a contrary holding that the UCP doesn't apply renders every regulatory taking unconstitutional, because in that absence, there would be no statute which could provide for the determination of just compensation as is required by the Constitution. With that, I would reserve the remainder of my time for rebuttal. Thank you, Your Honor.
You have the time. Paula?
Thank you, Judge. May it please the court, Assistant Attorney General Darren Fowler appearing on behalf of the state defendants. I simply want to make sure that the full panel is aware that the Mount Clemens matter that was the subject of the purported assignment that the association had attempted to put into evidence earlier in this appeal, that Mount Clemens matter is going to be heard by a different panel of this court, Judge Hood presiding on November 2nd. And so that case simply kind of bespeaks why association standing doesn't make sense here. Entities need to bring damages claims in their own right. Taking the cue from the court, I understand you've reviewed the briefing, so I'll simply answer any questions the court has.
Well, is
No
anybody
question.
going to talk about 24/7?
Certainly, Judge Savito certainly would have given me a nudge to do that too. 24/7 fitness certainly controls on the merits of the underlying question. And that's why Mount Clemens simply had nothing it could ever have assigned here, because there is no cause of action at the end of the day. As it relates to the analysis on the Court of Claims jurisdiction, the association here is trying to use the fact it is allegedly or arguing that it's entitled to compensate, to have a jury determine whether it is entitled to compensation on a takings claim as its foothold into circuit court jurisdiction versus a court of claims. The 24/7 fitness case tells us there is no cause of action for takings here. They're bringing the association is trying to bring the same type of claim that 24/7 fitness brought in terms of applying the takings analysis to these pandemic orders. Similarly, Mount Clemens individual plaintiff is trying to do the same thing on the same theory that the association is. So all of these cases ultimately, there is no standing. The jurisdiction is properly laid in the Court of Claims for dismissal of claims of action that just don't exist.
Questions?
No.
All right.
No.
Thank you, Mr. Fowler.
Thank you for your time.
All right, rebuttal?
Just quickly on the 24/7 case. First of all, all takings cases must be decided on a case-by-case basis, especially regulatory takings cases. They cannot be disposed of on general principles. Secondly, there was a key difference in the 24/7 case and this case. In that case, the court focused extensively on the fact that the plaintiff there had conceded that the state was acting properly. That they had no issue with what the governor was doing in terms of whether the governor was permitted to do that under the law, In this case, we are contesting that. We're alleging that the state had acted improperly and outside the bounds of its authority. So that's a key distinction. Respectfully, the 24/7 court also made a critical error in its Penn Central analysis as to the character of the government's actions factor. That factor analyzes whether the state's action has singled out the plaintiff to bear the burden of the public good, or whether the state's action burdens and benefits all citizens relatively equally. However, in the 24/7 case, the state held that that factor weighed in favor of the state because the state was acting to address a public health crisis. But the purpose of the government's actions is a due process consideration. It is not a takings consideration as stated by the United States Supreme Court in Lingle versus Chevron. And so for that reason, the court's holding was an error. And lastly, and similarly, the court erred when it held that there is a broad harm prevention exception to general takings principles. Again, Lingle versus Chevron clarified that this exception is rooted in due process principles, which had been historically intermingled in early takings cases. However, after Lingle versus Chevron, that exception has never been cited again by the United States Supreme Court. It's been completely abandoned, and so it should not be invoked here. Thank you, Your Honors.
All right, the matter is submitted. Thank you both very much. Excellent briefing. I believe we're moving to our 11 o'clock call. With that, I'm going to call item number 6, docket number 356780, in Re Shandu Mansharamani Living Trust. Is
Your Honors, we're having a little bit of technical difficulties getting the proper appellant on this case. She is trying to get in. We're just having some trouble. So I don't know if you want to move on to the next case, or maybe we can give her a couple minutes.
Yeah, well, what do
We'll
you?
follow your lead.
Okay, all right. You know what? We'll recall it, Sean.
Okay, thank you.
Once you connect with her, just let us know. All right.
Will do.
We're going to move on to item number 7, docket number 358176, Lamar Baskin versus Ali Mahmoud Saeed Namr. I didn't correct, please correct me.
May it please the court, Steve Hicks on behalf of the plaintiff, appellant, and cross appellee Lamar Baskin. This is an appeal from a summary disposition ruling in a no-fault third-party case, ruling on threshold. There is also a cross appeal dealing with comparative negligence and whether that bars my client's claim. I plan to focus on the issue we lost on, which is the no-fault threshold issue. As for the cross appeal, I'd be happy to answer any questions, but primarily I'll rely on my brief for the cross appeal and then address anything that I think needs to be addressed on rebuttal, and I'll reserve some time for rebuttal. I say that this is a no-fault threshold case because that certainly was what it was styled as in moving for summary disposition below. When the defense moved, they basically identified the first prong of the McCormick versus Carrier test, which deals with whether the injury was, the impairment was objectively manifested. That was the focus in their briefing. But as this court has probably come to recognize in recent years, the argument du jour in no fault has less to do with threshold and more to do with causation in cases where someone has some evidence of a pre-existing condition. And I could point to any number of cases. I think the most important one is probably Patrick versus Turkelson, because it's a published case, 322 Mishap, if I can read my own writing, 395 from 2018. That's a published case, and the only reason I mention it is that is a case where they dealt with the threshold issues in the case, and they worked through the prongs of the no-fault threshold test, but then they had also addressed causation, because they said, you know, it appears that the defendant is also arguing causation. And I think that's also true in this case, although it's styled as an issue of objectively manifested impairment, it's really not. And every judge on this panel, I did a little research last night, every judge on this panel has had a similar issue in the no fault context. In fact, one of the unpublished cases I attached, Ali versus Clark or Geico, it's sometimes called, was a case that Judge Letica was on, where the court very clearly said, hey, these are distinct issues and we're going to analyze them as distinct issues. Judge Hood, you're on a case that I had earlier this year, Harris versus Pollitt, similar result. Judge Servito, Smith versus Auto Club, similar analysis, looking at both the no fault threshold test and then looking at the causation issue. Why do I say it's not an objectively manifested impairment? Why do I say that? I don't say it's not an objectively manifested impairment. My argument is that it is. Why do I say that's not the issue here? Because I think it's pretty clear that we've got objective manifestations all over the place in this case, starting with the maxillary fracture to his face, the ventral hernia that he later has surgery on, the herniated discs that can be found at multiple levels in his cervical spine, multiple levels in his lumbar spine, his diagnosis of post-concussion syndrome and a mild traumatic brain injury. Objectively manifested is really not the issue here. The argument that the defense has made is that he had a pre-existing condition and therefore you haven't shown that these injuries, these impairments that kept him off work for 15 months after the accident are related to this high-speed collision he was involved in on the Lodge Freeway. The pre-existing condition that they point to, it's pretty vague. It's okay, he had some sacroiliac arthritis. All right, well, the sacroiliac is the hips. So there's some hip pain that he was dealing with. He had at various times, much like myself, complained of low back pain, neck pain, and on occasion stomach pain throughout a 25-year period. But nothing with the specificity with which he was treated after this accident. He went initially to his doctor, Dr. Krieger. Dr. Krieger diagnosed him as having post-concussion syndrome based on some memory loss issues. Krieger referred him to Dr. Hassan, a neurologist, who confirmed that. And you don't need to look just at what the treating physician said here. The fact is State Farm, who was the PIP carrier in this case, did not one, but two IME examinations of Mr. Maskin. The first, a physiatrist, Dr. Lurchin, found that his injuries were caused by the accident. There's no question she said that, contrary to their argument in the trial court. But she also found that 9 months out when she evaluated him, he had reached maximum medical improvement. So she may have thought it was not that serious an injury, but that has never been their argument in this case, that he didn't have an effect on his lifestyle. With regard to Dr. San, a neurologist who did an examination of Mr. Baskin as well, he also confirmed causation. So the bottom line here is that they have no medical evidence to support the position that they're arguing this case, is that his injuries were not caused by this accident. All they've got are the fact that he had a pre-existing condition, one involving the hips and various complaints over time. He's roughly my age, I believe, of low back pain, cervical pain, and evidently some stomach pain at some point during that period. So I think it's pretty clear on causation that the trial court got it wrong in basically ruling, and you can read what she said on the record. She basically said, given the evidence of your pre-existing condition, I don't find that this was caused by the accident. So I'm asking that the court reverse on those grounds. Again, I'd be happy to address anything that is mentioned in the cross appeal, but I can also just respond to that in rebuttal and turn the podium over to Brother Counsel. All right, thank you.
No questions. Thank you very much.
Good morning, Carl Lanfear on behalf of appellant, and I'd be happy to proceed however the court likes. I could do my very brief response as the appellee and move right to my other argument if you'd like. I don't have much to say on the appellee side. I think the problem for the plaintiff is that while they provided the court with some medical records, they lack the type of record that a court usually relies upon. That is a medical professional saying within a reasonable degree of professional certainty, this was caused by this accident. There was a plethora of records that he has irregularities in his spine, as do I, as do probably most people of our age in this room, but nobody's saying that it reached a causal level to this accident. I agree that's a little bit of a proximate cause argument. As to the fracture, she just found that it was a non-displaced fracture that was essentially no treatment on and didn't rise to the level to impact his life. But I sometimes think that the easier course and the more straightforward course would have been the ruling on sudden emergency. And I really think the court is pretty much going to be bound by the Van der Leen Supreme Court case. And the issue here, I think, is that there are two elements to sudden emergency. It has to be unexpected and unusual. And on a case direct land point like this case, the Supreme Court found that there was no need for that instruction, where a driver said, I looked in my rearview mirror. In that case, he was looking to see if his load was secured on his commercial vehicle. And when we look back, traffic had stopped in front of it. And the Supreme Court eventually ruled that that's not anything unusual, and that's not anything that's unexpected beyond the routine experience of a driver. And I think the court below was bound a little bit by the record offered her by plaintiff's counsel, because that was the only deponent in the case. And so there is no testimony. What he has to show, among other things, is that he didn't expect the stop, and also that it was not present for a sufficient amount of time for him to observe it. And there's no testimony to that effect. His testimony is he gets down the lodge and he cuts over 2 lanes. He wants to cut over a third in relatively short order. And that pretty much the entire time he's checking his rear view mirror or side view mirror to see if he can merge into the next lane, looking for that point of danger for impact. There is no testimony, none, that he looked into the lane he attempted to enter up ahead and saw whether there was stopped traffic or not. So what we have here is a 2-second look or a 3-second look, but no record created where the court below could conclude this was something really unusual and he should not have been able to anticipate it. That's his burden of proof on sudden emergency, not ours, and he didn't offer that to the court. So for that reason, I think the court should be reversed. The summary disposition should be entered in our favor.
Questions? All right.
Thank you.
Thank you. Rebuttal?
Thank you. Just a couple of quick points with regard to our appeal on threshold. I would say that with regard to the standard that the defense is saying, and that it's not the sort of testimony needed to support our claim that there is causation. I just refer to McCormick. In McCormick, the court said, medical testimony is generally, but not always, required to make this showing. So he's setting a standard that is not actually the standard. And then second of all, I'd note that there isn't any real discussion of the medical evidence here. So I'd reiterate the point I made earlier, that all of the medical evidence provided, including the IMEs done by State Farm, agree on causation here. And causation is his argument. It's really not objectively manifested impairment. I think defense counsel, and this is true below too as well, I think they've always been enamored more with the summary disposition motion that they brought, arguing that my client was more than 50% responsible for the accident. Certainly they have some arguments to make in terms of whether he should have seen a vehicle in front of him in the lane. But having just made that white knuckle drive down the Lodge Freeway to get here to court on time, you know, it's a treacherous one. And in this case, I think the facts are somewhat important. You have Mr. Baskin who merges onto the Lodge Freeway, and then he's gonna go on I-94 to get to his work. So he gets over to the left because he's gonna have to exit to the left on I-94. So that's what he's doing in this context is entering the freeway and getting over. I mean, they can certainly argue to the jury that he should have taken more precaution, that he should have been able to slow or move from that lane, etc. Okay, good argument to the jury. But at the end of the day, we are a comparative negligence state, and their burden is to show that he was 50% or more at fault. What we've got here is a car that was, by all accounts, other than defense counsel's briefing, in the far left lane, either slowing or stopping. And all of this discussion in their briefing about other cars not having had any problem going around it. Well, if it's slowing or stopping, this is an event that's happening, and it's happening in front of Mr. Baskin. He's very likely one of the first to come upon it, and he fails to avoid it. All of the cases they cite, I think this is important, all the cases they cite, including Vanderland versus Vadima, the one they mentioned today, are all contributory negligence cases. And when you look at those cases, when you take a look at them, they're not cases that were decided on summary disposition. And I pointed that out in my reply briefing in this case. They're all cases that went to the jury, and then the plaintiff ended up losing on contributory negligence after having presented evidence. We haven't even gotten there in this stage, and that's all we're asking to do. I think the trial judge got it right on this part of the case, denied their motion as to the comparative negligence argument, but got it wrong when it came to the threshold analysis. So I asked the court reverse. Thank you.
Thank you. That matter is submitted.
Number 6 is ready.
Sean, are we ready?
Your Honors, we do have the pro per appellant in this case. I just want to inform the court that she was in the wrong courtroom this morning, but that is due to my error and not hers. So she was here on time, but I will let her in right now.
All right. Great. We're going to call item number 6, docket number 356780, in Ray Shandu Masharamani Living Trust.
Film over.
Sorry.
We cannot hear you.
Can you press your video button?
We are Rita Mansha Ramani, complainer and plaintiff, and Mom Karuna Mansha Ramani, complainer and plaintiff in the courtroom through Zoom.
Yes. You are the appellant in this matter, so you may proceed. Please know that we do have your brief, so we have reviewed that and we've reviewed the response. So our role today is as an error correcting court. Can you give us a summary of why you believe the lower court erred in your case? Ms. Mancharamani, are you there?
Yes, we both complainers are here, requesting to close account and arrest orders to named criminals.
What?
All right, I'm sorry. Could you repeat that? We're having a difficulty hearing you. Are you by your microphone?
Why do you want repeat?
We didn't hear the statement that you just made.
Requesting financial trust cases to be closed and funds to us, and you have the named of criminals or defendants and the named call outs, they to be arrested, and forfeiture assets, fraudulent collection of funds in our names.
All right. Is that your argument today? All right, Miss Mansharmani, I'm going to let the other side speak, and you can reply to anything that they argue. Was there something else that you wanted to say other than the statement that you just made?
no કરી જાય. Radiation we give after long night.
All right. We're going to proceed and we're going to allow the FLE to speak. You're also endorsed for argument, and then you may reply. Counsel.
Well, Your Honors, Eugene R. Hamlin appearing on behalf of George Heitmanis Law Group as appellee in this matter. Just going to briefly state that a number of grounds for appeal that are brought by the appellant are unsupported by the record, citation, or supporting authority. And I ask that it be determined that they've been abandoned. However, if the court believes that it has not been abandoned, I would just want to indicate that the standard is that the rulings is abuse of discretion, where the lower court's decision was made outside a range of reasonable and principled outcomes. Based on the record, the trust itself states that beneficiary can't terminate it, and also that they cannot direct where the funds go. So based on the terms of the trust, the court did not err. And I ask that the court affirm the probate court's lower court's decision. Thank you. Any questions?
Thank you.
I think we have any questions. Thank you both for your briefing. All right.
Thank you, Your Honors.
Rebuttal. Ms. Ansharamani, this is your opportunity to speak to the argument that was just made.
It is a private trust and it has taken 9.5 years. And you are still not telling us the claim amount to have the financial trust cases closed. No one else authorized your bank accounts and collect political funds. Never in the past. Arrest the named defendants since you're referring to the brief. And defendants I don't see in appearance at the court hearing today. And we are both complainers, Mom Karuna and Rita Mansharamani. And their Hyde Harbors also to be arrested. Private Hindu charity.
All right. Well, thank you both for appearing today. And we're going to submit the case and we will have a decision to you as quickly as we can.
Where are the defendants? We don't see them in the courtroom. And why no appearances for them? They need to be arrested. Lisa Lagon, Neil Mansharamani, Savitri Bama, Hero and Indra Mansharamani, Situ Shivdasani, along with her twin terrors getting 5 generations of assets, and Sadhu Vaswani mission in their linkage. Arrest Namrata Kanal.
All right. We appreciate you both appearing today. Thank you very much. And the matter
My
is
mom was not given a chance to call.
We will get you a decision.
Stop suppressing cases here.
John. All right, we're going to move on to the next case on the docket. It is item number 8, docket number 358978, Mark Creamer versus Brian Daly. We have Mr. Collier is the only one endorsed. Mr. Collier.
Good morning. My name is Trent Collier, and I represent the appellants Brian Daly and the Daly Law Firm. The case has been briefed. We didn't get a response to our brief, so I don't want to overstay my welcome. I would like to just highlight 2 points and then answer any questions the court might have. There are really 2 key questions that the trial court answered wrong. The first question is, as of May 26, 2017, was there anything left of the attorney-client relationship between Mr. Daly and Mr. Creamer? At that point, Mr. Daly had completed the first-party claim and the third-party claim. At that point, Mr. Daly had also grieved, Mr. Creamer had also grieved Mr. Daly. And when Mr. Daly offered to represent him in further proceedings, Mr. Creamer said no. So I think as a matter of law, there was no attorney-client relationship at that point. Then just the last question is whether this is the kind of claim that needs an expert, because of paragraphs 12 and 13 in the complaint, which allege that Mr. Daly didn't do everything that a lawyer should do in a first and third party claim. This is a claim that requires an expert, because your average layperson doesn't know
what one would do in a first and third party claim. The average lawyer probably doesn't know that.
That's not something that the trial judge could spell out in a jury instruction. I mean, different from accounting or construction or other areas of expertise. If it's the practice of law, that's not something that the trial judge could just spell out in a jury instruction that directs the jury, this is what would be required.
I think not. And the reason is, the first element of a legal malpractice claim is breach. And so the first question for the trial court is, how are you going to prove breach? And because the plaintiff conceded they don't have an expert, there's no way that they can prove breach here.
Okay.
If there's no further questions, I'll yield my time.
Cerrito? No? Okay. No further questions. Thank you, Mr. Collier, for appearing today. The matter is submitted. We'll call item number 9, docket number 359788, in re ATS Harris Minor. And in case you weren't here when the 10 o'clock call occurred, these proceedings are recorded. So we would ask that you refer to the children involved here by initial. All right. And we have Ms. Bender. Thank you. All right, you may proceed.
May it please the court, Sarah Bender for the University of Michigan Child Welfare Appellate Clinic on behalf of the appellant, Ms. Montevia Harris. Your Honors, in January 2021, all of the parties to this case were in agreement about one thing, that there was a better way to resolve it than terminating Ms. Harris's parental rights. DHHS and the trial court were both in support of granting Mr. Williams custody instead. 10 months later, things seemed to be headed in the right direction, and there was no reason to think that anything had changed in this respect. was by all accounts doing well. Ms. Harris was visiting regularly and in fact had requested additional visits with her son. And Mr. Williams had finally gotten a court date and an appointed attorney for his custody proceedings. This didn't matter to the trial court. It decided it had waited long enough. It terminated Ms. Harris's parental rights without ever explaining why doing so was suddenly in AH's best interest. Sadly, this wasn't the first time that the state had given up on Ms. Harris. It had done so again back in February 2019, when Mr. Williams, for the first time in his son's then 5 years of life, entered the picture. As soon as he expressed an interest in gaining custody of his son, the state completely shifted its focus from continuing to make reasonable efforts to reunify Ms. Harris with her son to securing placement and then a custody order for Mr. Williams. The state cannot terminate parental rights after ignoring a parent for 2 years, and it certainly cannot do so when it itself has identified a better alternative for the family, as was the case in this proceeding. I'm happy to answer your questions or can continue to address these two errors in turn.
Just a quick question for you on the issue of or kind of the overlapping issues of abandonment here, or likelihood of abandonment. I'm wondering in the record if there is additional evidence that the respondent was confused about her ability to continue visitations. Aside from the comment that she makes to the one caseworker, is there other evidence that she was just confused about whether or not she could continue visits once was placed with the father?
Yes, Your Honor. So as you noted, there was Ms. Houstel-Jones, the caseworker who took over the case in November 2020, noted that as soon as she made her first call to Ms. Harris, this was the first call that DHHS made to Ms. Harris in 2 years. As soon as she made that call, Ms. Harris expressed to her that she did not know her case was open. The previous caseworker, Ms. Bird, alluded to this as well. She characterized it a bit less favorably to my client, however, noted repeatedly to the court that Ms. Harris was under the impression that the case was closed and Mr. Williams had full custody and there was nothing else she could do. Ms. Harris testified to this as well, and there's also notes in the record regarding the fact that Mr. Williams actually told Ms. Harris that he had already secured custody. And he, at that time, the DHHS caseworkers were directing Ms. Harris to him in order to facilitate visits, and he repeatedly obstructed these. So it's, I think, fairly evident why she was confused about the status of the case and also the nature of her rights to her son at that time.
Thank you.
Can you give me a timeline on that?
Yes. So the period of abandonment, according to the DHHS and the trial court, began in late 2018, late December 2018, and it continued until November 2020. However, as late as February 2019, so 2 months into this period, they were describing Ms. Harris as being, quote, on the cusp of reunification. There were repeated references in the DHHS did not make very consistent documentation of when Ms. Harris reached out to them. So the exact dates of when she was calling, texting, and showing up to DHH offices is not available in the record. However, caseworkers testified later to the fact that she was doing this. She was contacting the previous caseworker, Mr. Davis. She had on 2 different occasions gone to DHHS offices, and Ms. Bird attested to the fact that she, again, was numerous times trying to get in touch with Ms. Bird in the fall of 2019. So again, right in the middle of this period of abandonment, to find out, quote, if and when she could visit her son. DHHS's response to this was to refer her to dad and ask them to both work it out among themselves. And Ms. Bird never followed up to ensure that this happened. At some point during this 2-year window, Ms. Harris did see her son. Again, this was during the COVID-19 pandemic, but she was able to video FaceTime with him, despite the fact that Mr. Williams was obstructing visits. But again, that's kind of the rough timeline of the different points of contact that Ms. Harris made during that alleged period of abandonment. And again, she was very much active in this case. She certainly was not willfully absent from her son's life. And abandonment, desertion, this court and Michigan case law makes clear both of those are willful acts. I'd also just like to highlight the fact that abandonment was only invoked by DHHS and the trial court when it needed to check a box to expedite the proceedings. Ms. Harris re-entered her son's life November 2020. Again, as soon as Ms. Houstel Jones gives her a call, she's back on track with visitation and looking to resume services. The subsequent hearing in January 2021, after Ms. Harris is once again visiting AH again, and immediately after this period of, quote, abandonment, immediately after this, the court is on board with a custody order. No one was talking about abandonment as being a reason to continue to move forward with termination. The only times that abandonment was invoked as a significant reason to move forward, first with the supplemental petition in 2019, and then in 2021 to move forward with termination, is as a way to check the best interest box. It was pretextual, it was patently false, not only because Ms. Harris was present and trying to make contact with her son during that time, but also because the court repeatedly made clear that termination was not in AH's best interest, even during this time that Ms. Harris was not able to make contact with her son. It was purely pretextual. The court, when it made its best interest determination, made no allegations, no indication of why suddenly things had changed since January 2021 to November 2021. All of its statements regarding best interests were conclusory and inconsistent with the record. It stated that Ms. Harris did not have a strong bond with her son, but no one had ever said this. However, there are numerous references in the record to the fact that caseworkers described AH as being, quote, well bonded with his mother and, quote, a happy child around his mother. Once she was resuming visits in 2021, she was again attentive, seeking to arrange individual visits with him because she recognized that when she did visits with both him and his newborn sister, he couldn't play on the play state with her, and she wanted to be able to do that. She was attentive to him. He had a strong bond with her and cared about having that playtime, and she was receptive to it and very much looking to continue to strengthen her bond with him. Again, the court's best explanation for why termination was in AH's best interest is that he was doing well with dad. that cuts in favor of continuing to work towards a custody order. There was no reason to think that AH wasn't doing well, wasn't thriving under the status quo, and that his interest long-term wouldn't be better served by waiting a couple more months and trying to get that custody order where his mother would continue to be a part of his life. So again, the abandonment claim is patently false, invoked solely to check a box and as a pretext for the court's own interest in moving these proceedings along and closing out this case before DHHS. I'd like to make a few more additional points regarding DHHS's failure to make reasonable efforts to reunify Ms. Harris. Again, this failure to make reasonable efforts creates a hole in the evidence, not only with regards to the statutory grounds, which include a forward-looking component, but also with regards to the abandonment and desertion grounds that the court invoked, since it demonstrates that Ms. Harris's failure or lack of contact with her son during this time was not willful. Again, during this no contact period, DHHS, there's no record of them ever making a call. There's no record of them ever picking up the phone to contact Ms. Harris and explain to her that her case was still open, even though it made clear that it knew that she was confused about the status of her case and about the fact that she had a diagnosed intellectual disability. It's known about this since she was a ward of the state herself. And again, it doesn't matter. They never even called her, despite knowing that when sharing complex verbal information, previous psychiatric evaluations made clear that one needed to, quote, frequently seek feedback to ensure that she accurately comprehended what was being said. Still, no calls. And in fact, they ignored her repeated attempts to get in touch with her and to arrange visits with AH. Repeatedly attested to the fact that she was making such contact, trying to make visits with her son. Instead, they refer her to Mr. Williams and never follow up to see if Mr. Williams was actually allowing those visits to occur.
Can I ask, and
Sure.
maybe I'm confusing it because we have more than one of these cases, but wasn't this the case where she at one point worked through the girlfriend for visitation because he had groped her during a medical visit?
Yes, so this was in 2021 when she had understood the state of the case and was again making visits
So that
with
was
AH.
not in this abandonment period.
Yes, so in 2021, and I think this just kind of speaks to the fact of why it is necessary for Ms. Harris to retain rights to her son. You know, again, every indication in the record is that AH's needs are the day-to-day needs are being met living with Mr. Williams. We're not contesting that. However, it's clear that Ms. Harris played an important role in his life. And when Ms. Harris does not have rights to her son, Mr. Williams is not going to be someone who allows a healthy relationship to foster between Ms. Harris and her son. It's necessary for Ms. Harris to have rights to her son. It's also a constitutional obligation. However, I think, again, the record is clear that Ms. Harris was a positive influence in her son's life. And where she retains rights, she is better able to, again, remain a part of his life. But you're correct, Your Honor, that was an incident that occurred and unfortunately, and one that the trial court, or excuse me, DHHS did kind of neglect to find accommodations around ensuring that those visits could occur appropriately. Just kind of back to Mr. Williams and some of the obstruction on his end. Mr. Williams, during this period of no contact, misled her about the status of the case, indicating that he already had custody and the case was closed. And then again, when Ms. Hester-Jones took over in November 2020, she made clear she was able to get in touch with her, quote, in just a few minutes by simply looking in the system and calling the last number that was there. And in that immediate conversation, it's clear Ms. Harris didn't know that the case was open. She wants to resume visits. She wants to resume services, and she immediately makes good on those indications and is back on track by the court's next hearing in January 2021.
Others? Anyone have any questions? Because I
Great. If there's no further questions, I'll reserve the rest of my time. Thank you.
Thank you.
Thank you.
Good afternoon, Your Honors. Jennifer Rosen, Assistant Attorney General, appearing on behalf of DHHS. And I would like to clarify about the mother visiting with the child. she did not follow through with the visitation that was offered to her. First, she claimed that she did not have a bus pass that would allow her to travel to the child when the child was placed with an aunt. However, that information was counteracted by the fact that the DHHS testified that she had a regional bus pass, which would give her no limitation in her travels. The worker tried to contact, or the mother, actually, I'm sorry, the mother contacted the worker in April of 2019 to ask whether or not she could visit. And the visits were made available to her, but mother never followed through. The same thing happened towards the end of 2019 when mother contacted the foster care worker for visits, but mother failed to follow through. She did visit after there was some contact in 2020, but she's also missed visits after that period of time. The mother was provided.
How many visits, Ms.?
That she missed?
Yes.
I'm uncertain as to a specific number, Your Honor. And the mother testified that she did not want to visit the AH as well as her new child at the same time because it was too overwhelming for her. How is she ever going to care for two children at the same time if a visit is too overwhelming for her? She was provided services from 2014 until 2016. She completed that treatment plan and the child was returned to her care at that time in 2016. So it is clear that the mother does have an understanding of the services being afforded to her. She does have an understanding of what she needs to do in order to accomplish those goals. When the child was returned to foster care just 15 months later, she was offered services again through a court's order, and she failed to comply with those court's orders. She absented herself from the proceedings for 2 years. She admitted during the supplemental termination hearing that she knew that the hearing or that the case remained open in the court, and yet she did not come forward until November of 2020 to make herself available again. She cannot be a person who floats in and out of a child's life. The court is not obligated to facilitate a custody order when a person is not a positive influence on a child's life. She is not doing things to increase her bond with her child. She is not doing things to reinforce her bond with her child. And because of that, the court made the decision that it would be in AH's best interest to terminate her parental rights rather than continue on with a treatment plan that was going nowhere, rather than continue to assist in facilitating a custody order that would realistically just be the child where the child is now, with the father caring for the child's daily needs, and the mother just being a mere visitor in the child's life. Are there questions that the court has of me?
No.
No.
See any questions?
Thank you, Your Honor.
Rebuttal?
Thank you, Your Honor. I'd like to first address opposing counsel's points regarding my client's visitation history. The transportation, the bus incident that opposing counsel refers to were all from 2018. And the evidence regarding in the record regarding whether the bus pass was actually adequate for meeting her transportation needs is contested. 2019 onwards, she was, by all accounts, very consistent with visits. In 2021, the two visits that she missed, 2 visits during this year, and both were clear in the record. The DHHS records made clear that this was because her car broke down and DHHS could not get her bus tickets in time for these visits. Otherwise, she was attending all visits in 2021 and was described as being very attentive to AH. She wanted extra visits with AH, not just individual visits with him, because as I mentioned in my initial remarks, she was worried that the visits that included her newborn daughter weren't adequately meeting his needs and allowing them to deepen her bond. all of the records in this, all of the evidence in the record makes clear that she was very attentive to deepening their bond. It's stated in my brief. There were numerous instances in 2018 where caseworkers described how receptive she was to incorporating their feedback to deepen her bond. This was true through 2021. And again, all of these reasons are pretextual. All of the concerns about the bus issues in 2018 that DHHS and the court raised in these closing hearings are pretextual. It wasn't enough for them to think that termination was appropriate in January 2021, and it was not grounds for them. They repeatedly made clear, even after these alleged issues, that they thought that a custody order was preferable and would better serve AH's interests. That's the key point here. All of these grounds invoked are pretextual. The court itself identified a better alternative and just got sick of waiting for it to come around. I'd just like to add, with regards to these comments about AH deserving more than a visitor in his life, Mr. Williams was a visitor in AH's life for 5 years. For the first 5 years of his life, AH lived exclusively with his mother or maternal relatives. When he was placed with maternal relatives, Ms. Harris remained an integral part of his life. And at best, Mr. Williams was an intermittent babysitter. That is clear in the record. Yet DHHS completely shifted its focus to this visitor in AH's life because it wanted to close the case out. And it continued to put all of its eggs in Mr. Williams' basket, even when he was sleeping through custody hearings that it had arranged, even when it was obstructing visits that Ms. Harris had a right to. I don't think that this visitor argument, again, I think it's pretext. Ms. Harris has been a more consistent figure in AH's life, has by all accounts been a positive influence when she has been able to have a role in her son's life. And the periods in which she's been able to play anything less than, in which she's been able to provide less care for him than she provided in 2021, immediately before termination occurred, it was not by her own fault. It was because of DHHS's failures, Mr. Williams' obstruction. And so for these reasons, because reasonable efforts were not made, because termination was clearly not in AH's best interest, there was a better alternative that the court itself recognized was preferable to termination. Both errors merit reversal. Thank you, Your Honors.
Thank you.
Well briefed. The matter is submitted.
Well argued too.
Yes.
Great job.
With that, we'll call item number 10, docket number 360553, in re K.A. Pete Minor, and that will be submitted on the briefs. And with that, we're adjourned.
Are we going to get a link to talk? Annika?
Yes.
Are we going to get a link to talk? We can go over the
Your Honors, I
cases.
believe I sent it just
Okay.
about 20 minutes ago.
All right. Thank you so much.
How much time would you like, Judge Servito?
It's up to you guys. I
Why
want
say-
a little bit.
Why don't we say 1 o'clock?
Okay. What time is it?
It's 1:45.
Okay. That's fine.
Okay. All right.
Okay.
Thank you.
Thanks.